welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas million strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
So, I am going to, they, of course, you know, they have not started, right? I don't think they have found the jury, but let me put on, while we are waiting, on it, let's do this, because I haven't watched any of her motions hearings. So that's why we waiting, guys. Wait a minute. Let's see. I just want to make sure I got it pulled up, so when it's time for us to get in there, we are in there, baby. Let's do this. So I know they had one on Monday. Let me pull that up and let me check and see if I have any other updates on my phone regarding jury and stuff like that. Okay, yeah, this was the one Monday. So this is the one for Monday that they had. And we'll just go in here and take a look until they actually start the one from today. Let me see what else I got for you guys. Yeah. Because I guess we might as well go ahead and get into it. Have that there. Okay, cool beans. Welcome over. You say they always late. Let me see what we got going on here. I'm sorry, guys. I'm going on here. Let me just play this while we waiting, and we can listen. Just to kind of give y'all an idea, this is from the hearing that happened on Monday. So this happened a couple days ago. So that's what this is from. So let's listen in. And it was in regards to something in regards to witnesses. Okay.
Begin the impanelment. I know that there was a motion to eliminate filed by the Commonwealth last week, and it was to, and it's pleading number 129, Commonwealth's motion eliminate to exclude defendants' undisclosed expert witnesses. So I've had an opportunity to review Commonwealth's motion in the attachments. I've had a chance to review the defendant's opposition. And so why don't I hear first from the Commonwealth, and then I'll hear from the defendant. Commonwealth?
Thank you, Your Honor. The Commonwealth's moving for the court to exclude the 4 expert witnesses detailed in the July 7th witness list defense counsel provided to the Commonwealth, or in the alternative to continue the trial so that we can prepare for those witnesses. We received that witness list on July 7th. There were many nurses and doctors on that witness list, many of whom have worked with the defendant in the past. So we weren't clear as to whether the doctors were people she had worked with in the past or if they were experts that we weren't aware of. So we emailed defense counsel asking for information about these experts or these doctors, and he responded pretty quickly. I know in his memo he says that they're not experts, but they're clearly experts. They're not fact witnesses. It doesn't appear that they knew her, worked with her, observed any of the events leading to these charges. The subject matters that the defense lays out in his notice and in his memo are subject matters that lay witnesses would not be allowed to testify about. Things like mechanism of injury, mental health, medications that are prescribed and the effects of those medications, and psychiatric standards of care, all of which would be expert witnesses. Now, defense counsel is an experienced attorney who understands the rules, and by providing these names at this last minute, a week and a half before trial, was a strategic and intentional act to surprise us with these witnesses and not allow us to be prepared for them. We have a right to prepare for witnesses, to obtain materials, especially with expert witnesses, to find out where have they testified before, what publications have they written, what is the basis of their expertise, and to get rebuttal evidence and or witnesses to be prepared for trial. If the Commonwealth had attempted to do the same at this last minute and bring up expert witnesses, they would be excluded without question. And I know the standard is different for prosecutors, but we all still have to follow Rule 14. And to allow defense counsel to call these experts would be fundamentally unfair to the Commonwealth.
All right. Yeah, Mr. Reddington.
First of all, I can't remember the last time the government, let alone defense, was excluded from presenting testimony by way of, quote, experts, end quote. Generally, it's a matter of fairness. What are they going to testify to? Does the government, in this case, they've got like 39 people working on this case, Judge, and to suggest that they need time to prepare for cross-examination of fundamental witnesses that depend on the direction of their case. For example, I have an emergency room doctor. He's a board certified emergency room doctor that I consult with to help me understand and interpret the medical records, the extensive medical records. South Shore Hospital dealing with the initial admission and the injuries. Brigham and Women's Hospital, she coded on this fake suicide. She coded and almost, and literally her heart stopped at Brigham and Women's Hospital. I need to know terms that I don't understand that this Dr. Velkovich is going to assist me with and has been assisting me with them. Now, I don't know what the government is going to say in their opening statement. So I can stand here right now and tell you, in all likelihood, I wouldn't call Dr. Velkovich as a witness on this case, but it depends on what they say in their opening statement. In the event that after their opening statement, there are issues in play that I feel I would be calling the doctor, I certainly would supplement. And they've already got all their CVs. I've already given them the CVs. As it relates to the psychiatrists, I've given them the CVs. I've given them voluntarily videotapes of their interview and evaluation of Lindsay. I have given them their notes. They've got every scrap of paper that my doctors, that would be Dr. Zeisel, Dr. Resnick, and Dr. Spinelli have. As it relates to, for example, the other doctor that's referenced in the defense disclosure to the government, Dr. Condi. Dr. Condi is not one of my experts. Dr. Condi is an individual who filed an affidavit dealing with the atrocious failure to have medical care that is consistent with the standard that is applicable, and that's in the civil suit. I summoned him. He doesn't know me. I haven't sat down with him and gone over evidence and everything else. I said, you're a witness in that case. You filed an affidavit. I'm summoning you, and I did. I have spoken with him, and I gave the government the affidavit that he filed in the civil suit. You then have my crime scene, if you will, blood spatter evidence. I don't expect that I'm going to be calling Dr. Condon. But when we got into this thing where they wanted to have whiteboards and drop, fluids on it and experiments in front of the jury, you remember that I objected, filed an objection, filed a brief, and indicated that I would have to have, I wanted a Daubert hearing. Your Honor allowed that. I then spoke to Mr. Condi, Dr. Condi, I should say, who I've dealt with before. Very, very well-known crime scene reconstruction gentleman, very qualified, board certified, on the boards and all these things. I'm not going to use them because we, as you know, are not going to be doing the experiment on the board. I am still going to consult with him as it relates to evidence that I think I have to ask him questions about. But right now, as I stand here, I don't expect to call him. So that's Dr. Condi on the affidavit on the civil suit. My crime scene blood spatter expert. I have my board certified emergency room doctor, and then I have Dr. Laposada. Everybody knows Dr. Laposada. She's no stranger to the courts. I've used her on many, many, many murder cases over the years. Dr. Laposada, as I stand here now, I don't know if I'm going to call her or not. It depends on, again, what the government argues in their opening. If they argue something in their opening that opens the door for me to slam them with Dr. Laposada, you can bet I will call her. But they don't need weeks to prepare for cross-examination. That's ludicrous to suggest that. So I think I have complied and then some with Rule 14. So I'm asking that the court, not at this early stage, strike the witnesses because I don't know if I'm calling them yet. And if I do, they'll get a report. They already have all their CVs.
Yeah.
I may, Your Honor.
Ms. Sprague, please.
We do not have 30-some-odd people working on this case. It's ADA Buckingham and myself working on this case along with our victim witness advocates. We've never made an allegation that defense counsel hadn't provided discovery pursuant to Rule 14 in a timely manner for the 3 experts that they plan on calling regarding criminal responsibility. What we're talking about are the 4 witnesses he's detailed in this last-minute notice of witnesses. And when he says that Dr. Condi is just a witness, he's not an expert because he's in the civil case and he hasn't talked to him, that doesn't mean he's not an expert. He's clearly an expert because he's talking about medical information, psychology, and medications, and the psychiatric standards of care that only an expert would know. And we haven't been provided anything but his affidavit, and his affidavit doesn't even state which standards of care is he talking about, and what he bases his opinion on. And most of his opinion is more likely than not. So there's nothing in that affidavit that would be compliant or would fully comply with Rule 14. In terms of Dr. La Posada, yes, I am familiar with her, and often in cases when she testifies for defense, she files a report at the last minute, giving prosecution little to no time to prepare for what she's going to testify to. We have nothing on her or any of these other witnesses as to what they plan to testify to, what their opinion is. There are no reports, no notes, no statements. Those are all required information so that we can be prepared so that the process is fair. And defense has to follow Rule 14 as well.
I mean, I understand the defendant's kind of argument that not knowing exactly what the evidence is, it's difficult to say what witnesses you're going to call. But at this point, the Commonwealth has presented their experts and what the opinions are. The defendant has provided significant discovery regarding the three experts regarding criminal responsibility. The other issues, it's almost like it's premature at this point to rule on this. I mean, if the Commonwealth's witness comes out of left field and gives an opinion that is completely different than what had been disclosed, that's a different analysis than if the witness says, I've been saying this for 2 years. I think that's a different argument. So I don't know yet. I'm assuming that the witnesses that the Commonwealth is going to call will testify consistent with what their opinions. And if that's the case, I may very well allow the motion to eliminate. But at this point, if they varied significantly, then I might have to view it a different way. It's a difficult motion in regards from the defendant's standpoint, because I don't have any opinions. Like Dr. La Posada, I don't know what her opinion is, right? I mean, it may be completely going along with the Commonwealth or against the Commonwealth. So it's hard to deal with that. Same with, well, Dr. Condi, probably not. Is it Dr. Condi? Is going to testify regarding the standard of care. I'm not sure if that's going to be any different than what the defendant's other expert is going to testify to. And there's already an expert who's going to opine in regards to that. The other is Dr. Valentin, but that doesn't sound like that's going to be an issue because it doesn't sound like the Commonwealth is going to do the seek to introduce that demonstration. It was that Dr. Volkovich. And same with the emergency room doctor. I don't know if anybody's even going to disagree with each other, you know? So I'm going to allow the Commonwealth's motion at this point, subject to it being renewed based upon what the evidence is as the case develops, if that makes sense. The Commonwealth's motion is to exclude the defendant's undisclosed expert witnesses. I'm going to allow that at this point, but I keep using the word allow, but allow the defendant to renew that depending on what the Commonwealth's either opening is, as you said, or what their experts say. If they say something that's unexpected.
The problem with that, Judge, respectfully, is that it hogties me on my opening, because I don't know until they make their opening if, for example, I would utilize Dr. Volkovich. I just don't know until I hear their opening. So if you're ordering me that I can't reference these witnesses or what their opinion would be, then it puts me in a very awkward position.
Well, it's not that awkward because you've got a situation where you're telling me you don't know what they're going to say. So how?
Because I can anticipate what they're going to say.
No,
I have their prior statements that they've made. I've got their various releases, I've got their Raymond argument, I've got all of that. So I have an idea what they're going to say. I just don't know they're going to say it or not.
Well,
No.
we go first, so then he'll know.
Well,
And then he can
exactly.
tailor
So
his
when I-
opening to that.
Here's what we're going to do.
So when I-
Here's what we're going to do. We're going to do just what I said. All right? I'm going to allow this motion subject to the defendant as the Commonwealth's case changes. Or if you want to come up
Yep, that's what we'll do.
after Commonwealth's opening, if you feel that that has opened the door in some way,
Yep.
I have no problem
That's fine.
hearing everybody over here. And same thing as the case unfolds. If you feel that something is said that's was unexpected or inconsistent with the earlier disclosure, by all means, come on up to the sidebar and we can talk about that. Okay? All right. Anything else we need to address?
No, Your Honor.
All right. So what I'm going to do is I'm going to get off the bench at this point. We'll bring the jury up, the potential jurors up, and then we'll begin impanelment as soon as we get everybody up here. Okay?
Okay, so that was the hearing earlier when they were picking the jury selection. No, they have not started today's motion hearing, but since I have not seen any of the motion hearings, I'm like, okay, well, they haven't started, so that means that we need to find something to watch or talk about during this period of time. Just want to kind of gauge where you guys are at with this. I don't know. I don't even know if I should gauge this whole little thing, but I mean, just to keep it on fairness, we like lurkers as long as you twerking. Are you lurking and twerking, or you lurking and working? I don't know. It depends on which kind of lurking you doing, Angela. Yeah, so I guess, you know, so I guess what I'll put just because I want to know where we're at as far as like us here at Take It to Trial, as far as our pose and how we are coming into this. So I'm gonna put up a quick poll. It looked like we may have some movement going in the courtroom, but I'm gonna put up a quick poll. This way it can be in, you know, nobody has to say the way they voted or how they voted. So based on the stuff that you may know now, just going in with the information that you know is basically what I'm saying. I'm not saying it has to be something that you are standing with or committing yourself to. You know, I mean, of course, you know, you can always change your mind. Like as you get new evidence or new data, you are supposed to reevaluate things. I just want to know what your temperature is as we are coming in from the stuff that you have seen. Because I can tell you, the other day, I was like, oh, she guilty as fuck. Like, you know what I'm saying? That's what I was like. And then yesterday, I'm like, okay, well, she not guilty. So I can just tell you, like, y'all know how I can be. I can be all over the place with these, and I'm okay with being all over the place. I have not one doggone problem with it. I like being all over the place and just having different things. But let me get up. I did have some other stuff, and I think that it may be a good thing for us here. I do have his civil complaint. You know, Patrick trying to get that bag. He said, drop that bag off. So he filed a civil complaint. And I do have a copy of the civil complaint. And I think that it would probably be well worth our while to look through it. Only because, you know, in a civil complaint, a lot of details can come out that are not going to come out in court. So all that stuff that we may see in the civil complaint that gives us like all the details and stuff, we may not see that in court because, you know, they are limited to what evidence comes in. So it may be very good for us to go through the civil complaint. I I didn't schedule anything, but yeah, I have no I think that we may should read over it just to kind of see what stuff now coming. Okay, wait a minute, I hear noise. Okay, here we go. Let me get us in the courtroom. Looks like they are gonna do it. So let me share it.
By Attorney Kevin Reddington, and the Commonwealth was represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right, so I think we have a motion. And why don't we take up was a request it's entitled, request by the father of the child victims to restrict display of and access to certain evidence and exhibits at trial to the jury and necessary parties. And what I thought I would do is first hear from counsel for the father, then I'll hear from Commonwealth, I'll hear from the defendant. So, counsel? Yes.
May I approach you?
Yes, please. Thank you.
Judge,
Please state your name for the record.
good afternoon, Your Honor. If it please the court, Ms. Sprague, Ms. Buckingham, Mr. Reddington, my name is David Meyer, M-E-I-E-R, and I appear to the extent that Your Honor allows me to appear on behalf of a potential witness in the case, the father of the 3 victims in the case, Patrick Clancy. If I could, Judge, could I see the court briefly at sidebar?
Sure, absolutely.
So this is Patrick's attorney. And so they are at a sidebar, guys. If you can't see, you can't tell. We are at a sidebar. Real quick. So this is going to be in regards to, let me get it up for you guys. Just while they're, because this is what he's about to be talking about. So just so y'all know. Let me get it up so y'all can see it. Why won't it let me share my Discord? Wait a minute. Okay. Hopefully it's sharing. Okay. So this is in regards to Patrick, who is the dad, filed a motion. Let me make sure. Okay, I just want to make sure I'm not muting anything back there. So as you can see, hopefully you guys can see the rules of impoundment procedure. He's respectfully requests that this honorable court to impound certain materials that he seeks to file in support of his request, to restrict display of and access to certain evidence and exhibits at the trial to the jury and necessary parties. Mr. Clancy does not seek to prohibit counsel for the Commonwealth or the defendant from having access to viewing the materials. As grounds, therefore, Mr. Clancy respectfully states that given the extraordinary circumstances of this case and the nature of the materials he seeks to file with the court, there is a good cause to impound the materials. It is well settled that the court may order the impoundment of information related to the criminal case for good cause shown. Boston Globe Media Partners LLC versus, such and such, such and such. So, because I think a lot of people is getting this mixed up with what he's wanting. So, in particular, Mr. Clancy respectfully requests that the court restricts the courtroom display. Oh, I got this too big. Shoot, I gotta pull this down some. Wait a minute. I can't see this. I can't scroll over. I should have did I think to fit. Let me see. Let me see if that'll do it. Okay. Nah. Okay. I just gotta do it like this. Okay. Oh, it don't have it all on there. Okay, I gotta figure out. Because I had it somewhere. But long story short, he filed this motion. It's not so much that he does not want the trial televised or anything like that. What he is saying that when they display the autopsy photos, any clothing of the children, the 911 call, he does not want the gallery. So the people that's sitting out there, like the media and stuff that's sitting out there, he doesn't want the gallery to see these things. I don't think anybody in the gallery, I know the places that are televising it, they're not showing autopsy photos, right? So I mean that's fine. I think the judge will declare that no, those photos cannot be shown to the gallery. I don't think he's going to get away with the 911 call not being played. I don't think he's going to get away with in regards to the clothes. I don't. So it's not that he doesn't want the trial to be streamed. I think he just doesn't want certain things to go out here. And pictures of the children. He doesn't want them to have pictures of the children prior to them being unalive. And it's well, those pictures are already out there. They are on the mainstream media. They're on the news. They're everywhere. Yeah, it's supposed to be public. They just having a sidebar, CC. I don't know why they didn't have a side, why they didn't do that. But maybe because he just got there. Because remember, the judge was in jury selection. They were selecting the jury. Yeah, so and I get that if he don't want the gallery to see autopsy photos and things like that. I get that, but there are reporters, guys, that are sitting in the gallery, that are out there, and they want to see every piece of evidence that's going to be submitted to the jury. Every piece, because they want to see everything. Once the jury has decided, they want to know how the jury came up to the decision that they came to. And in the meantime, between time, he wants to protect that part of it. You say, CC said, look, they doing all the hearings on sidebars. I think that they do have some more. Have y'all been able to hear me? Or I don't know. It looked like my thing was muted. Was it muted this whole time, or were y'all able to hear me? Put a 1 in the chat if you were able to hear me. Oh my goodness. Was I just sitting up there talking and talking and talking? Oh my gosh. I mute myself in places that I probably don't need to mute myself. I don't know. Oh my gosh. Oh, okay, good. Because I'm looking at my soundboard and I'm like, Oh my gosh, it's muted. All that shit I said. I was about to be upset. Yeah, so because at first I was like, okay, Patrick need to have a whole bunch of damn seats. You know, like go somewhere with that stuff. No, we are going to watch this trial. Like, you're not getting that off. Like, if you don't go sit down somewhere, but that sounds like that's not what he's trying to do. He's just trying to protect certain things about the case. They are still back there, of course. We cannot see it. Let's see here. What else I got up here? Yeah, I thought this order, I can't see the entire order. Let me see. I'm trying to see if I look at if I go to my Twitter, if I can see it. Maybe I can see it here. Let me put this down. Let me make my Discord smaller so that way y'all can just see it. Let me see if it'll allow me to share. Let me see. Okay, so this was the part that I was trying to read that was kind of like cut off. It's just saying, in particular, Mr. Clancy respectfully requests that the court restrict the courtroom display of any public access to, one, the audio recording of the initial 911 call made by Mr. Clancy, any photographs of the 3 child victims, 5, 3, and 8 months, including pre-incident photographs, crime scene photographs, and autopsy photographs, and any clothing associated with the 3 children victims to the court. The session clerk, the prosecution team, trial team, the defense trial team, the testifying witness, the court reporter, and the jury. So he's saying he don't want y'all them hanging up like the baby clothes. He don't want y'all doing that. He don't want them doing that. Okay. So I don't know why it's doing that. It's like sharing the wrong thing. So that's telling you that's giving you that information right there about that. You say you just tried to find a 911 call and they all been removed? I've never heard the 911 call. I never even knew it was on there. Interesting. Yeah, nah, we want to hear the 911 call. I don't know about anybody else. Like, nah, we should be able to hear the 911 call. What the heck? No, sir. We get to hear it. We want to hear the 911 call. And then this was the first part. The first part that I was reading, but I had most of that in there. Let me see. So let me look at my playlist. Let me see. Pre-trial. Because she had a pre-trial hearing last week, too. Yeah, this way we can kind of do some catch up in regards to some of the evidence or hearings that she had. Because like I said, I didn't watch any of her hearings. let me see. Okay, I was just trying to make sure that I didn't have any updates on X. Let me see. On Kathy's thing. Okay, and they still kind of have us out. We are going to be watching on NBC 10. Let me see. Oh, Real Happy said the 911 call has never been public. Oh, okay. Yeah, I kind of figured they were going to do the openness on Monday. I read somewhere else where they said that if the jury, they haven't picked the jury, I don't think. I think we still going to be in jury selection tomorrow, guys. Let me see. Yeah, so like her final pretrial hearing. Let me see. They still haven't returned, guys, just so you know. So let me remove this. I am going to here, and then while they are, I don't know, maybe CCG is right. Shoot, maybe they not gonna let us watch the hearing because they still over there. So this is the final pretrial hearing that she had. This was about 9 days ago, and this is where, if I'm not mistaken, from when I was listening to the news, this is where they decided to drop the strangulation charges. So, hey Denise, how are you, honey? How you been? Long time no see. So let's listen in and see what motions were handled in this last hearing. Cause I like I said, I haven't seen any any of this stuff. Like watched it. So let's see. And then I'll check and see if we got some more updates.
Then go through the general questions with the jury, then send them back downstairs to fill out this questionnaire. My other thought is that there is an extensive witness list. And it may make more sense to have the jury be handed a copy of that list, to bring that down with them when they're answering the questionnaire, because last I counted, it was over 200 names. And I think it would be difficult for anybody to sit there and try to remember who it is. Do I know that person or not? So my thought would be to give them the questionnaire, give them the witness list, send them downstairs to fill that out. That then gives us an opportunity to take a break, line up for the individual part of the voir dire, and then bring them up and bring them in one at a time into the courtroom over here at sidebar, and just proceed that way.
I think that's a good idea, Your Honor. I would just ask that those witness lists be collected from the jurors as they leave.
That's a good idea. Yeah. I have no, Mr. Reddington?
Yeah, that's fine.
All right. So that's the way we'll do that. Let me see. I have here's a draft of those questions on the. We can go over these on Monday, but this is being proposed. Don, could you hear those? Counsel.
And Your Honor, the witness list, would that be a combined list with both?
Right. It won't be listed as defense or Commonwealth witnesses.
Thank you.
So this is just a rough draft of the questions, and then bring them up. My thought would be to impanel 18 on this case, because it's going to be a lengthy trial. And then, so everybody's going to get, well, I know there's a motion for additional challenges. So why don't I hear you on that at this point? Mr. Reddington?
Are we going to talk about the questionnaire eventually, or?
Yeah, I'll give you, I just,
Okay. Your Honor, I have filed a request for additional challenges. I understand that you would be entitled to 18, is that correct?
Correct.
As I was told, you might
Yeah.
contemplate 18 jurors.
yeah, we're going to see 18.
So I'm asking, and I don't know if the government agrees, that we would have additional jurors. Obviously, that would be committed to your sound discretion. But it's the type of case, not only publicity-wise that we usually deal with, but just the sheer emotional impact that this case is going to have on jurors. And I have always felt that jurors really, take to heart their obligations under a jury trial. And I have literally had occasions where I've run into jurors from older cases, emotionally charged cases, in public places, and they would shake my hand and then cry. And that to be like 5 or 10 years later. And the impact of this case, which in my decades of trying cases, is probably the most emotionally disturbing and challenging, I think, is going to have a significant impact on jurors, more so than the usual that we deal with. So recognizing that 18 challenges might sound like a lot, I just feel that perhaps an additional number of jurors subject to your discretion would be appropriate, especially with the length of time that they're talking about, along with the emotional factors.
Come on.
I would join in the request for the additional peremptory challenges. And I just have a question in terms of if the court is going to impanel 18 about the seating of the 2 additional, because we want to make sure they have adequate viewing of the monitor and the witness box. But other than that, I have no objection.
All right, I want to consider this motion. With both parties requesting it, puts in a little different path that you usually have on this. So, but I do understand the uniqueness of this case, the allegations. So I'm going to take that under advisement. We'll let the parties know in the next day or two. So that'll be under advisement. And in regards to the seating of the jury, my thought would be, which I've done before, is to have not to have those 2 side by side, but one in front of the other. And I think we haven't had that problem before in regards to being able to see either the witness, because it kind of lines up, and then the screen, which I imagine is going to be used here. Might have to turn it a little bit, but the cases I've done before with the 18, all the jurors were able to see. And then what we'll do is I'll just ask them as we're going through this. If everybody can see this, if you can't see it, let us know. If we have to adjust the screen or adjust the seating at that point, we'll do that. But I haven't had that problem. But I don't have them side by side like that. So, all right. Any other questions in regards to the impanelment, Commonwealth?
No, Your Honor.
Mr. Reddington?
I don't think so.
I mean, I think we've all done cases with each other, so I would expect they'll be kind of handled the way we've done it before. So, that would be the impanelment. As I said, with the schedule, as I indicated over here, I'm going to tell the jurors what the schedule is going to be, but let them know that it's a fluid situation in regards to how long the trial is going to be, how long the schedule's, on a day by day. So I'm not going to be very precise, I don't think. And we'll talk a little bit more maybe on Monday in regards to how I address that with the voir dire. Let me see. The other issue that I had, just in regards to, and I know Mr. Reddington indicated that you don't believe there's going to be a request for the defendant to be absent from any of there. And so what I would, just so the parties would know, if that comes up under Rule 45, what we'd do is we'd just do a colloquy, maybe do a signed waiver, and we could deal with it that way. So it wouldn't take up a lot of time. I think it's just better for everybody to know that's the procedure that I would follow, kind of after looking at the case law on that. In regards to the view, I know that I had
Okay, so just so everybody know, we were just watching a hearing that they were having. This was her final pretrial hearing. I have not seen any other pretrial hearings or anything like that. So while we were waiting on our current motions hearing, I figured it would be a good opportunity for us to look back and look at this hearing or any of the hearings that she had, to see how the judge decided on what evidence is coming in, who's going to be able to testify, who's not. They are back in court, so I'm about to take us live into the courtroom, guys, just so y'all know. So this right here is back live in the courtroom with our motions hearing that what's going on. You said it was previously taped. Okay, I'm gonna see what I can do, Lynn. I'm back here working and trying to see, because even if we can get a transcript, I did hear some things that were said on this 911 call, and maybe we'll hear some of it today outside of the. I don't know how this gonna go. Let's see. Let me just play. Let me get us in here.
Very briefly, Your Honor. Again, as I indicated to the court,
is that her parents?
To Ms. Sprague and Ms. Buckingham and Mr. Reddington. Thank you, first of all, Judge, for the opportunity to be heard. As everyone is aware, I'm not here as a lawyer representing the Commonwealth. Neither am I here as a lawyer in any way representing the defendant. On behalf of Patrick Clancy, the father of the three child victims in this case, he recognizes, and I recognize on his behalf, that he has no authority, no standing, and no intention of suggesting to this court or to the attorneys how to try their case, how to conduct direct or cross-examination, and perhaps most importantly, what evidence or exhibits should be introduced during the trial. Mr. Clancy, respectfully, Judge, is not seeking to close the courtroom at any time during the trial. Mr. Clancy is not seeking to address the admissibility of any evidence or to exclude any evidence from the jury, and he's not in any way seeking to prejudice the Commonwealth or the defendant in any way. What Mr. Clancy is seeking through counsel, Your Honor, respectfully, is to restrict in a very limited way the display and access to certain specific limited items of evidence and exhibits at trial to the jury, to the court, to counsel, to the court reporter, to the session clerk, and to the court officers. That is, the necessary parties who will be involved in trying the case. And I respectfully, Judge, I suggest that pursuant to the so-called Massachusetts Victims' Rights Bill and other statutes and cases with which the court is familiar, as a victim, as a family member of the three victims in this case, Mr. Clancy respectfully has an opportunity and a right to be heard through me or through his counsel. I suggest to the court that certain items of physical evidence or certain exhibits ought be restricted from dissemination and distribution, quite frankly, locally, nationally, and internationally, as is the case in this day and age. And for purposes of this hearing, respectfully, Judge, I would ask the court, and I would ask that the record reflect that the recording of the so-called 911 call allegedly made by Mr. Clancy be marked or be included as an exhibit for purposes of this particular request. I would also ask respectfully, Your Honor, that Any photographs of the three victims in this case, whether taken prior to the alleged incident, whether so-called scene images, whether photographs or video recordings of the three victims, or any so-called autopsy-related photographs of the victims be marked for purposes of this hearing. Likewise, Your Honor, respectfully, I would ask on behalf of Mr. Clancy that the clothing being worn by the three victims during the course of the alleged incident also be reviewed by the court and marked as exhibits. And lastly, Your Honor, respectfully, given the background that I summarized for the court and counsel on the record at sidebar, I would ask that the material that I have submitted to Your Honor from Patrick Clancy and correspondence that I've shared with both the prosecution and the defense and the court and have submitted to your clerk be also marked as an exhibit, and that it be subject to the motion to impound, which I have filed on behalf of Mr. Clancy, given the nature of that correspondence. In short, Your Honor, I am asking that based on the law, based on Your Honor's ability under the rules of impoundment, and specifically the rule as I understand it on behalf of Mr. Clancy and is cited by Your Honor in your initial order, which I believe is docket number 111, entitled Order Pursuant to Supreme Judicial Court Rule 119, that Your Honor does have the discretion to limit certain recording and certain transmitting of proceedings during the course of a trial. And specifically, as Your Honor knows, that rule, Supreme Judicial Court Rule 119, entitled Electronic Access by the News Media to Court Proceedings, states in one part that a judge may limit or temporarily suspend such access by the news media if it appears that such coverage will create a substantial likelihood of harm to any person or other serious harmful consequence. And the Supreme Judicial Court rule goes on to say a judge may impose other limitations necessary to protect the right of any party to a fair trial or the safety or the well-being of any party, witness, or jury. I suggest to the court that under those provisions, upon reviewing each of those four different categories of potential evidence and the correspondence from Mr. Clancy, that certain limiting rules should be adopted by the court and imposed on the media in this case. Lastly, Judge, I refer the court respectfully to two specific cases in the Commonwealth which respectfully did not rise to the level of the extraordinary nature and facts in this case. One of which, Judge, was a case involving the alleged sexual assault of a young child, which was tried in Middlesex County several years ago. And after the conviction and after the case, a private documentary filmmaker sought access to the recordings of the witnesses who testified in court. And ultimately, the SJC found that the trial court's conclusion that the privacy interests and the emotional harm to the victim and her family outweighed the First Amendment right of the media or a documentary film member to get access to the actual recording live voices in the courtroom. And instead, the SJC, Justice Gantz, indicated that the proper mechanism, given the circumstances of that case, was to allow the documentary film member or the media access to the transcript, that is the written word. Likewise, in that case is Commonwealth versus Winfield, W-I-N-F-I-E-L-D. Similarly, Your Honor, I respectfully direct the court's attention on behalf of Mr. Clancy to a case tried in Essex County, Commonwealth versus Chisholm, C-H-I-S-M, in which then trial judge Lowy heard a motion to suppress when there was a videotape and a recording of a defendant's statement. And ultimately, the media sought access to the videotape statement to disseminate and distribute outside the courtroom. And the SJC ultimately upheld Justice Lowy's decision at the trial court level to allow the media access to a transcript of the videotape and a transcript of the defendant's statements, but not the actual videotape. Given that precedent, given Your Honor's discretion, given the spirit of the Supreme Judicial Court rule that applies to the electronic recordings of proceedings in your courtroom, I end as I began and ask the court on behalf of Mr. Clancy that certain limiting instructions to the media would be appropriate with respect to the 911 recording of Mr. Clancy's voice, certain photographs of the 3 child victims, and the clothing worn by the 3 child victims in this case. And again, on behalf of Mr. Clancy, I thank Your Honor for the opportunity to be heard.
All right, counsel, thank you. Attorney Sprague?
Thank you, Your Honor. With regard to the 911 call, Your Honor, I believe it's a public record available at a public records request, but I would defer to the court in terms of how you want to restrict publication of the 911 call during the trial or thereafter, as long as the Commonwealth is still allowed to show or play, rather, the recording for the jury as the court has previously allowed that motion. Regarding photographs of the children, we had already addressed the autopsy photographs. The Commonwealth was going to request impoundment of those, and we would agree that they should not be broadcast or photographed in any way. Crime scene photographs, the children had already been removed from the home when the crime scene photographs and video were taken, so they will not appear in those photographs. The only blood in those photographs would be the purported blood of the defendant in the bedroom and on the exterior of the home, and then a small amount of blood from Cora in the basement. In terms of pre-incident photos, there has been mass publication of photos of the children already, but I would defer to the court on that as well. And regarding the clothing of the victims in this case, the clothing would be a shirt and pants that Dawson was wearing, pajamas and a bathrobe that Cora was wearing. There's a small amount of bodily fluid on the pajamas, and then pajamas that Callan was wearing. But although some of the material has been cut as they were cut away from the children, as EMS were working on them, trying to save them, there's nothing about the clothing that I think would suggest the need for restriction of publication of those items. So that's the Commonwealth's opinion.
All right, counsel, thank you. Attorney Reddington?
Let's call a spade, Judge. I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having Patrick Clancy, who's a young man who has suffered one of the worst tragedies that anyone could ever suffer, How that guy is still not an emotional basket case is beyond me, and he has been. But nevertheless, he is trying hard to move on with his life. He has, as the court is aware, they're divorced. He's remarried. He has a family. He has his extended family. Your Honor heard statements, and I know for a fact that it's true, that his family, totally innocent people that have nothing whatsoever to do with this case, are being harassed daily by news media, the New York Post, and all the rest of these types of salacious news media outside their door. This is his family. Some of them are in California. They have nothing to do with this case. But nevertheless, they are being hounded by the media. And the district attorney wants to put that guy on the witness stand and show little onesies with bodily fluid of his child. And they want to have him stand there, or they're going to let him stand in the hallway while we listen to the 911 call.
Mr. Reddington, that's another issue. That's another motion. The question we have right now, respectfully, is Mr. Meyer's request as to how we should deal with this in regards to the media.
I agree with Mr. Meyer's request, as I told you with the sidebar. I think it's very appropriate. I think he argued it effectively. I think that Your Honor is well aware that you have the authority under the SJC rules to enter limiting orders, if you will, as to publication, as to what media can publish, what photographs they could look at and report. And I agree with what he had indicated to you in his argument.
All right. All right.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away
All right,
what happened, and focus on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
No, I stopped that. And if you want to address that in a different way, then we've got another motion in about 5 minutes that we're going to probably be talking about that. So let's talk about that then. This is I let counsel go and think it was going to wrap back up, and I didn't see that it was going to wrap back up in regards to the request. So that's why I stopped it. All right? This is not accomplishing anything in regards to the question of access to these 4 pieces of evidence. So I've got everybody's position. I've heard the arguments from counsel. What I'm going to do is I'm going to take it under advisement, and then what I'm going to do is issue an order probably tomorrow morning. And parties know I've listened to the tape, that 911 tape. I have looked at the autopsy photographs. I have looked at a crime scene video, which I imagine is where the crime scene pictures will come from. And so I'm familiar with the universe of the evidence that we're dealing with right now. I want to take tonight, go over the arguments from parties. That's why I'm stopped a little bit, everybody. I just want everybody focused on that issue. So I'm going to take this matter, the request of Mr. Clancy under advisement, and I will be issuing an order in regards to that request sometime tomorrow morning. All right? Now, there's one other motion that we have to address, and I believe that is the defendant's motion to limit witnesses. Is that correct? That's the motion we have. All right. Now, what I'm going to, I've read the motion. All right. I've read the grand jury minutes from all the individuals who have scheduled to testify. So I'm going to hear from the defendant just in regards to this, and then I'll hear from the Commonwealth. So, Mr. Reddington.
Thank you. And I will restrict the hyperbole. This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, let's face it, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial, to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street, dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement. Another firefighter heard noises, was outside. Another firefighter, Duxbury Fire Department EMT, saw Lindsay on the ground, was treating Lindsay, heard screams coming from the house, went into the house, describes the basement scene. Another Pembroke Fire Department individual, paramedic, same idea. Another Pembroke Fire Department paramedic was in the house. Duxbury firefighter EMT saw the other EMT carrying two kids out of the basement. Saw two children on the floor, described the basement. Marshfield Fire Department paramedic went in the basement, saw the children laying on the floor in the basement, on their backs facing upward. Saw blood, what appeared to be blood around the nose of one of the children. Another firefighter, Marshfield, assisted in the basement, heard the screaming, yelling, and made his observations. Another firefighter from Duxbury in the basement saw the children, little children, wearing onesies and feeties, laying on their backs on the basement floor, assisted as he could. Another Duxbury Fire Department individual, basement. Another Kingston Fire Department mutual aid gentleman, assisted in the basement, describes what he saw in the basement. Another Kingston Fire Department individual saw Pat, heard the screaming, and went downstairs, describes what he saw in the basement. Another Duxbury Fire Department individual responds to the scene, describes the scene, and then Duxbury Fire Department individual responds, saw Patrick in the kitchen, saw him sobbing, and made observations of the scene. So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves. And it may have worked in the grand jury, but it shouldn't work in a jury trial.
Counsel, is this motion, I understand the rationale behind it, but isn't this motion kind of a little premature? Because I mean, if you're talking about something being cumulative, don't I have to hear what the first witness says first, and then ask for the Commonwealth if there's an offer of proof? There's anything different that this witness saw or did or is going to bring to the jury? And I guess what I'm saying, it's difficult for me sitting here right now to tell the Commonwealth, you can't call witness number 2 without knowing what witness number 1 is going to say. I appreciate this kind of flags the issue for me. It's helpful. You know, I went back, I pulled out proposed Rule 403 that talks about, you know, needlessly presenting cumulative evidence, so I could be aware of that. Got the cases pulled out for that. But I don't have everything in front of me. That's what I was. That's the way I was looking at it right now. But Commonwealth.
Thank you, Your Honor. So in a typical murder case with one victim, we would be proving deliberate premeditation and or extreme atrocity or cruelty. Either one of those, proving first-degree murder, you'd have to prove that the defendant's actions caused the death. And the way we do that is with the person finding the body, then the people who treated the body trying to save that person, then the medical staff at the hospital treating them and then declaring them dead, and then the autopsy confirming that the actions of the defendant were the cause of the death. Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children. And so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you, we don't need that. All right? We don't need that. The question right now for both of you is, this is a motion saying that there's going to be cumulative evidence. I don't know what's going to be presented. So how can I say that witness 2 doesn't bring anything extra after witness 1? I understand the theory. The Commonwealth, and I'm not telling the Commonwealth how to try their case. I'm not. And I guess the issue has been brought up that the defendant views the Commonwealth's approach one way, the Commonwealth views it a different way. I'm the one who's going to have to decide, and I don't have anywhere near enough information right now to determine if something violates, you know, Section 403. But I understand the Commonwealth's position. There are a number of witnesses, and they all may very well bring something unique to the Commonwealth's case. So it's really what I'm probably going to be doing as we go through this is have everybody come over here to the sidebar, hopefully calmly, talking about an offer of proof. And is this witness bringing something? If they do, fine. I'm not restricting the Commonwealth thing. I appreciate the fact that it was brought to my attention. Now I can be aware of it. And we can just deal with it as the trial goes on. Just like, you know, I mean, like we said, all of us have tried a number of homicides. So we know how it's done. And so I'm aware of how the Commonwealth has to prove multiple elements in every case. And so I'll be cognizant of that. So I guess probably just so you'd be prepared that the defense objection will be, it's cumulative. And we come over here, and if there's some reason why, there's something else that this witness brings, or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right, all right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties read. This is exactly why we have motions to eliminate. So I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is, so I'm kind of ready for that as well. So I'm not going to take any action on that motion and eliminate. Like I said, I'm sure we'll be talking about that a little bit later. Anything else we need to address today? Counsel?
No, Your Honor.
All right, defendant?
No.
All right, so the plan, we're going to be in recess on this matter until Monday. Parties should be prepared to give openings. I'll give a very brief pre-charge at that point, and then we will just begin with the evidence, hopefully Monday morning. And I will try to get that order out in regards to Mr. Clancy's request sometime tomorrow morning. All right. So again, I want to thank everybody for kind of helping me get through these issues today, and thank you for all your hard work on this. So we'll be in recess until Monday morning on this.
Court will rise.
This matter is continued to Monday, July 27th, 2026 at 9 a.m. for the jury trial.
Please play the courtroom, please. Thank you.
What?
So there we have it. The judge said he not ruling on nothing. He gonna go home and take a nap and think about it. Opening statements begin Monday in the evidence. Boy, this is gonna be spicy because the prosecutor lady, like, she gonna have her foot all. She gonna remind her every chance she get about these three babies. Every chance she gets, she gonna remind her. She gonna have her foot on her neck. Yeah. So if Lindsay got a long, oh my gosh, like, this is ew. This is gonna be like a whole hot mess. And I only say it like that because we now have confirmation that Patrick, like, look, I'm about to sue all the drug companies. I'ma stand by your side. I got my new wife and my new family, and we need some money. I'm telling you, as quick as he get his silver money, boy, he gonna be out here on a rampage. He don't have to sit back and be completely quiet. So right now, he has to support the whole thing that the drugs is what did this to her, because if the D-drugs is what did this to her, this would support his civil claim. Right? Oh my gosh, and he all the way remarried. Like, does he bring his new wife in? I hope they have a babysitter. Please don't bring your new family in, Patrick. Oh my goodness. Right there is enough to make you want to crawl up under a table and don't never want to come back. Like, I couldn't even imagine. Where your B-Day, Christian? You didn't tell me that. You say you think your work is done here? Well, you have a great birthday weekend. I don't know. You didn't tell me. What day is your birthday, Miss Lady? The 25th? Oh, Saturday. Okay, little miss. Have a good one. Oh, yeah. You know, I'll be ready to play my happy birthday song. Can I play my happy birthday song? Can I do that? You want me to do it now or you want me to do it Monday? When you want me to do it? Y'all have to let me know when y'all birthday is because I be want to play my song now. I want to say happy birthday and I want to sing my song. I want to do all that stuff. Like I be wanting to do it. Yeah, let's play our birthday song. So do y'all want to do we want to listen to some more of some of the other pretrial hearings, or do we want to go back to our code thing? Maybe we should break this down some more. Let me play this song and then we'll break down some more of this stuff here.
Everybody rise. Everybody rise. Court is now in session. Today we're here for a special confession. The evidence is clear. There's no denial. It's your birthday. Here it take it to trial. All standing proud. Got the whole room lit. Got the whole room loud. No filter, no flow. Just facts today. You get the gold crown. We don't play. Happy birthday. The verdict's in the day. Another year of greatness. Let's celebrate your way. Judge says party. Jury agrees. We got your name up in the sweetest degree. Happy birthday to you. Happy birthday to you. From taking to trial. We're celebrating you. Happy birthday to you. Happy birthday to you. Sweet Pea Gang. Sweet Pea Gang in the aisle. We're celebrating you. Birthday wishes delivered with ease. Cake on the table and you got the keys. Another year wiser, another year fine. Still the main event, still the headline. The final ruling, the trial. Have the best birthday from Take to trial. Hands in the air when the name gets said. All love all day from the floor to the head. No objections, let it ring. One more year for the birthday king. No objections, let it ring. One more year for the birthday queen. Happy birthday to you. Happy birthday to you. From taking to trial. We're celebrating you. Happy birthday to you. Happy birthday to you. Sweet Pea Gang. Sweet Pea Gang in the aisle. We're celebrating you. Ending tag. The verdict is in. You're officially another year fabulous. Happy birthday from Sweet Pea and the Sweet Pea Gang. Everybody rise.
All right. Yeah, y'all have to definitely let me know when we can do our birthday song. You know, we always trying to do that. We always trying to get up in there and do that. Yes, happy birthday. Let's see here. Yes, so definitely enjoy your weekend. And turn down for what? Don't you turn down. So, I guess I'll take it from here with you guys. Do y'all want to continue to watch some of the pretrial motions? I haven't seen any of them, so it's totally up to you guys. Or do we want to go back to watching our Colin Gray trial? Because it looked like we'll be in, you know, of course we're going to be in sentencing tomorrow, guys, for Cope. And then we'll be in sentencing next week for Dad. Do you guys want to go? Do y'all want to finish watching that, or we want to watch some more of the live hearings for, well, some of the other hearings for her? Man, I'm telling you, really just the facts. Like I haven't seen any of it. Like I haven't seen much of it. I I haven't seen much of it, to be honest. Like, so I've been trying to really like figure out what is going on with it. And in order for me to kind of figure out what's going on with it, I've been putting a lot of stuff in Discord so I can kind of understand. Because I was gonna do us the case prep for this, and I mean, when I was looking at doing the case prep, I started getting pissed off, so I stopped doing it. Let me see. You think that's, I was just looking at Denise. I see you put this, that's really her, you think? Oh wow. I wonder, is that gonna be something that they're gonna show in the trial? Probably not. I don't know. I don't know if it's still up or not. But yeah, so if you look in the Lindsay Clancy thing, post pic. Can you post the pic, Sweet Pea? Where you want me to post it? You want me to post the pic of? Oh, I didn't see she put all this stuff in here. Wait a minute. You want me to go over the ones in Discord? Now, I'm going to say allegedly. Oh, SD, that put you to guilty? Oh, shoot. Let me see the best way that I can share. Let me see. Let me see. Wait a minute. I'm trying to see how I can show this window. Like, okay, so allegedly, because I don't know if this is her or not, guys. So it says Lindsay Marie Clancy. This is the search box, right? And this is her name. This is May 5th, 2021. And this incident happened when? Remind me. Oh, I gotta go back to our thing, guys, if I'm gonna remember. Okay. It says, hello, lovely parents. I am looking for some advice, some solidarity, some ideas, something, anything. I am truly finding my 19-month-old to be the most difficult human I have ever encountered. I mean that with all the love in my heart, but honestly, I cannot make it through a day without getting so frustrated with him. He is not my first child, so not to compare because I know every child is different, but just for background, this isn't my first rodeo. Every single thing with him is a battle. And it has been this way for a while, since he was maybe like 8 months old. I really try to pick my battles and only do what's completely necessary. But I mean, everything is getting out of his crib in the morning and going downstairs, changing his diaper, getting him dressed, getting him in the seat to eat, getting him in the car seat, getting him out of the car seat, putting on his jacket and his shoes to go outside, having him come inside when it's time, going to sleep for his nap at night. He fights me every step of the way with all of these very normal daily activities. It constantly feels like I have to force him to do these things, which feels so wrong. But he's always fighting me and crying about doing normal things. What do y'all think about that? If that's her. If that was something that she wrote back in 2021, what do y'all think about that? Here's the next one. Thanks so much, Denise, for posting this stuff. Okay, and that's just saying that Lindsay Clancy, if you guys didn't see it, I don't know if this stuff is coming in or not. It says Lindsay Clancy, mass mom, accused of killing her 3 children, research ways to kill. Holy moly. Oh no, why is she researching that? That is none of your business, lady. Oh man. So yeah, there we go. Yeah, I don't think we have access to the 911 call. I think that they may have been listening to some transcripts or something, but I was trying to even find the transcripts, but I couldn't even find those, guys. So I don't know about that. I think Court TV was just reading what he was saying, kind of, sort of. Can you not get the live? When you say cannot get the live, it was in one of the pretrial hearings. Really? Where we heard, okay, let me see what I can do. Let me see what I can look up, guys. Because like I said, I haven't heard any of the pretrial hearings, so this is like my first time going through them. Let me see if there's a way that I can search and find it. Let me see. I don't know, because I don't know why I feel like I've heard like bits of it or something when I was doing the research, but maybe I wasn't. Maybe I didn't. So while I'm looking to see what I can find, I am going to you posted it in Discord? Okay, let me see. Oh yeah, there it is. Okay, let's see. Let's listen to it. Um, thank you. Let me get it up here, guys. Thank you so much. Let's listen. And I don't know how Patrick talk about somebody up there stalking him and bothering him and his family. Didn't nobody even know that he was married. What are you talking about? So trigger warning for anybody that the trigger warning for anybody that does not want to hear this, you know, trigger. Just so you guys know, I don't know what other way to say it. Okay. Let me put me back on the screen and that. Okay, let's listen.
Hey, one Don.
Can y'all hear it?
Engine 2's on. Square Fire Dispatch Engine 2, car 3A14747 Summers Street, respond with the police. The whole party jumped off the top floor of the house. She did slice her wrist as well, and neck injuries, neck laceration. She's conscious at this time. We're going to check with med flight. It was over a 20-foot fall, 1814. Fire alarm to car 3. Car 3. Car 3. And police are responding. Just use caution. She did use a knife at first. Unknown where that is at this time. Got the update. Thank you. Units respond and go to the backyard. She's going to be located in the backyard. We have her. She's in the backyard. Fire alarm 2, car 3. The ETA from MedFlight, all their units are tied up. If needed, UMass can be called. It'd be a 35-minute ETA. Received, okay. Well, I'm going to show car 3. Name 1, come in. Car 3, A1 on location, 4-4 as commanded, 1816.
Yeah, I wasn't really saying nothing besides them talking about she jumped from 20 feet. Okay. Hey, Billy, I heard that you watched the movie, so you allowed to throw hot dogs.
Fire alarm, come in. Fire alarm's on. Put a box alarm in. I need a second ambulance to the scene. Receive, go to the basement, Cap. Go down. Cap, go to the basement. Two possible suicides. Box alarm for coverage, and I need a mutual aid ambulance to the scene. I need a second ambulance to the scene. Receive, go to the basement, Cap. Go down. Cap, go to the basement. Two possible suicides. Box alarm for coverage, and I need a mutual aid ambulance to the scene. Receive, do you have the message? Go to the basement. Dog spray fire, strike in the box. Dog spray fire, strike in the box. Second ambulance request. It's 4747 Summer Street. 1818.
Fire alarm, start a mutual aid ambulance.
Got him on the way. We're with the county.
I got 2 pediatric arrests in the basement.
Violem has the 2 pediatrics arrests. We got a mutual aid on the way. We're going to get you 2 mutual aid at this time.
4-0's on the air responding.
Nancy 4-0. Fire alarm, Summer Street, come in. Sir in command. Need a 30 ambulance to the scene. 30 ambulance to the scene. Chief, I'm going to get all 3 mutual aid at this time. Summer Street, come in. One update. I'm getting you 3 mutual aid ambulances, Cap. I struck the box. We got 3 on the way. Okay, I got 1 here. I got 4 patients total. Total, I got it. File on to command. I have Marshfield, Kingston, and Pembroke on the way with ambulances. Duxbury Fire Line paging the deputy per the request 4-0. Duxbury Alarm paging the deputy per the request 4-0 at 1822.
Duxbury Fire, Kingston A2.
Answering Kingston A2.
Responding, Summer Street.
Kingston A2, you're on responding. Thank you. 47 Summer Street.
Yeah, can you get one of the other cops down here to help with compression so we can do some other stuff? Pembroke A3, Duxbury Fire Alarm, we're on responding to Summer Street as well.
Pembroke A3, you're on responding 1823. 47 Summer Street.
No visible emotion, no obvious concern.
So that was all that was on. Okay, so that was all that was on the recording. So we just only hearing the dispatch. So we not hearing the dad's actual stuff. So we may have to do a little bit more research. But yeah, I think that that's like my problem with all of this when we go into this trial. You know, just hearing from the different things from everybody. Let me take this off. I think that the way, if they can get it off, y'all, the way that they gonna be able to get to win this thing without any issues or anything like that. So this is like the little timeline that I put in Discord just so we can kind of like have some. Oh, I ain't gonna lie, that's gonna be too big. So just the morning of what was going on, right? So it appears that morning, just so I can make sure that I follow along as we going through this trial of what happened and what things were going on. So clearly they said in the morning she took the 5-year-old Cora to a doctor's appointment. Everything was fine. They came back, built a snowman. They played in the snow. Everything was normal. Okay. At 4:02, she starts searching on her phone and she is looking for kids Miralax, and she's also looking for takeout from 3V. She checks the drive time to 3V on Apple Maps. She called CVS about the Miralax. The CVS person is probably gonna come in and testify, saying she sounded normal. There was nothing out of the ordinary. Her and Patrick text back and forth in regards to what they're going to eat, what the menu looks like. Then she calls 3V in order to place the order. I am sure that the person who took her order at 3V is going to come in and testify, saying that she sounded normal. Now, the time that Patrick actually left the house is, I don't have that exact time, but I'm assuming it's it got to be between 5:10 p.m. and 5:32, because according to the receipts, Patrick arrives at CVS at 5:32. Right now, Patrick calls, because you can see him. We're gonna see him on video in the CVS making a call, and that call that he's making is to Lindsay, and he's asking her about the medicine. Now, it's to my understanding, the first call she didn't answer, and the second call she answered, or she called him back or something. Patrick said that she seemed like she was in the middle of something. Clearly she was, right? Patrick arrives at 3V at 5:54 p.m. to go ahead and pick up the food, and that's on camera. Patrick arrives back at the house at 6:09, and that's where he, of course, the house is silent at this point in time, and the bedroom door is locked. There is blood on the floor. Open window, finds Lindsay with wounds on her neck and her wrist, calls 911. So Lindsay is breathing and semi-conscious. Patrick yells she killed the kids. I'm assuming that is going to be caught on a 911 call or something to that effect. This is where it gets really funny for me in regards to this case, is because Cora and Callan were found in the basement, the end area. Dawson, for some reason, was found in the basement office. So it seemed like they were in different rooms. She used workout bands that were found tied around the children's neck. Now, I was listening to a show, and this is what I need to, what I'm wondering if the prosecutor's going to drive home, that even with her being in a psychotic, manic episode, when does this episode start? When does this, I got to kill, and I don't have any control over it? When does it start and when does it end? Or what does that look like? And that's going to be really, really important, at least for me to understand this, because, of course, since I'm not psychotic, at least I hope not. Some days I might be psychotic. Well, today I am not psychotic, so I can't really understand and reconcile that in my head. So when I'm looking at this, I'm like, I want the prosecutors to, because unfortunately, it's when you strangle somebody, guys, it's not like in the movies. It's not you put your hands around them and they immediately die. And that's why the 8 month old, he passed away 3 days later, because she didn't strangle him. I guess I ain't gonna say enough, but strangulation takes a long time. So she set on these kids' necks or pulled these bands tight enough for a period of time. I don't know how she was doing it, if they was laying down and she did it, if they was turned around and she did it, but she did this for, even if you talk about a minute and a half. So you do a minute and a half, and then you move on to the next one, and then you move on to the next one. Like, this happened 3 times. Like, so I'm trying to understand, like, in none of this stuff, we never, I just don't know. Like, can we, like, in no point, way, fashion, we don't stop in, like, between the 3? And or did you figure it out and that's why the baby, I don't know. It's just weird to me. And then you go upstairs and you decide that, okay, in all of this, now it's time for me to end my life. I am going to slit my wrist, and I'm pretty sure the state is probably gonna show, look, the way she slit her wrist, man, we call cap. Like, you could have did more than that. We call cap on that. So she slit her wrist and she cut her neck and then she jumped from 20 feet. Like, I don't know if that's really a person trying to unalive themselves. Like, and then I think the defense can also make the argument that she was so in such a psychotic mode that she didn't even realize that jumping from 20 feet or, cutting her wrist in the areas that she was cutting it was even going to do anything. Yeah, so I just want to see how the prosecution team is going to, put this out here. I hope that they come out aggressive and say, look, we know that she had postpartum depression. We're not saying that. We know that she has it. But just because you may have postpartum depression, it does not lead you to unaliving all 3 of your kids. The other thing that I found that was funny, that was different in Massachusetts, and we're gonna have to really keep an eye on this. Not an eye on it. We're gonna have to really keep this in mind. And that's another thing that I have a issue with when we try these cases, because I'm not sure if the jury is able to know, look, if you find that she's guilty, it can be by reasonable insanity, right? And I guess we have to wait till we get the jury instructions. Because if they know that, I would like to know if the judge tells them, well, if you find that is reasonable insanity, no, she does not get to go home, ladies and gentlemen. That means she's going to be in a treatment facility for the rest, for a substantial amount of time. I think that what jurors find hard when they even go for a not guilty by reasonable insanity, they feel like they are letting a murderer get away, right? Like they're just about to be free on the streets. And I think that that'd be something like, I don't know how to explain it when they say it or how that goes, but it would be nice to know if that's something that they can do, because I think sometimes if the jury know that you're going to have some type of punishment versus to just going home, because a lot of us on face value, we just think that if you do not guilty by reasonable insanity, like Lindsay is going to be back out in 10, 15 years. And that's not the case. That she may very well be in that facility or wherever they put her for the remainder of her life. You say she need prison. So let me do this real quick. Only because I've been trying to like I said, I've been trying to really understand exactly what we're going to be getting into with this case. Probably more than what I care to be knowing. So I had to ask Google about this, and I'm pulling it up because so Massachusetts follows the McHugh rule. I think it's McHugh rule. I think one is the Magnotti rule, and then one is the McCool. Okay, the McCool. Sorry, the McCool rule is what Massachusetts follows, right? And so when you looking at it, it says it asks one basic question: because of a mental disease or a defect, did the defendant either not understand that what they were doing was wrong, or two, understand it was wrong but couldn't control their actions? So now Massachusetts follows the McCool rule. The jury isn't deciding whether Lindsay has a mental illness, because that alone isn't enough. So I think that the prosecution team should be able to just come up and concede that, yes, she got a mental illness, but just because you have a mental illness does not mean that you were not aware of what you were doing to your 3 children. They have to decide whether, because of her mental disease or defect, she either could not appreciate. And so then I had to go look up what they meant by appreciate in this part, because I was like, well, appreciate. Okay. She didn't appreciate that what she was doing was wrong or couldn't control her behavior. Now, if the prosecution team cannot prove this beyond a reasonable doubt that she was criminally responsible, the verdict would be not guilty by reasonable of lack of criminal responsibility. So, I guess the simplest way for us to kind of think about this is, because this is what has to happen. Mental health illness alone doesn't excuse her crime, right? So we got that. Under the McCool rule, the question is whether the mental illness took away the person's ability and the right to know right from wrong and control their actions. So, and when we're thinking about the word appreciate in this, like I told you, I looked it up to try to see how it connects to this. It says appreciate means more than just knowing. It means truly understanding what you're doing and that is wrong. That's important. So they saying that they have to prove that she, in order for her to be considered mentally ill, they have to prove that she couldn't appreciate it. So I think that may be something that, like, I don't know if they get there or don't get there. Yeah, so yeah, that's gonna be something that we that's gonna be very key when we get into this case and when we get into this trial, because that's what the state has to say. Nah, and I think the reason why the way they gonna be trying to prove it is like all the research is what will probably seem like a normal thing. And I'm not saying she never like researches the time it takes her husband to drive to another place or not. But with all of the ripple effect and everything that happened afterwards, it's hard to explain that stuff away. Like, I don't know, from the link that Denise put in our thing, and shout out to you, Denise, thank you so much. With the link that she put in there, like, when was she researching ways to kill? Like, when was this being researched? Like, does that come into evidence? I don't know if that's admitted in or if it's not admitted in, but that's important. I guess they can't use it as like it's more like a 404B, but if something like that comes in, that's very important, depending on the time frame, right? So if this is like weeks in the making. But I think that what also works for her a lot in her favor, man, regardless of what we try to say or how we try to swing this stuff or what we try to do, man, the damn girl, she was reaching out trying to get help. She was reaching out trying to get help. So no matter how we try to slice it and dice it or whatever we may think about it, like, it's not like a person that wasn't trying to get help. She was trying to get help. And that's what pisses me off. And that's what got me so mad about everything. 4 days? Okay. And see, that's what like she was trying to get help. And it was like nobody was like doing anything. So I put that just a little timeline in regards to, her medical treatment timeline, like her appointments and her therapy and all that stuff. And then the progression of her symptoms, with her anxiety and depression. And then her medication timeline, the medication and stuff that they had her on for you guys in order for us to kind of like keep track of all this stuff. Like, I heard from some, because I'm not a psychiatrist, I am not a doctor, but I did hear from some psychiatrists that were speaking about it, and they was like, depending on, I don't know how many drugs she had in her system at the time. At the time of the incident, but and we have to see with the cool down. I want to call it a cool down, because even if you change in medications, like, is there a cool down period for the medication to be out of your system before you try another medication? It hits on certain things like that's your serotonin levels, your nerve system, in order to make you think away. That's why when people are on certain psychotic medications, they like zombie like. But a lot of these medications that she was on, to be honest with you, like, these are like standard medications. Like, the first thing that you say you thinking about something and you thinking about it too long, the first thing they do is put you on Zoloft. That's standard. So that's the first thing. Trazodone. That's the sleeping medication. Like, so Prozac. Okay, we've been doing Prozac for a long time, but I know Prozac is also related to a lot of people, losing it, right? I'm pretty sure we'll get that, what medication she was on and actually taking, because I'm pretty sure they drew her blood and stuff, so maybe that'll come out in court. I'm not sure if it was in his complaint or not. I can go back and look, because I pulled all this stuff from the complaint to try to do it. I heard somewhere, or I seen somebody maybe put in the chat, that she was on like 3 drugs at the time. Okay, yeah, Denise said 3. You say SSRI drugs? Maybe so. Oh, only 3? And then my thing is like, well, if you got all the access to all these drugs, when you get the sewer slider thoughts in your head, you don't go take something that like calms your anxiety or anything to kind of calm you down? Or are you just really just like out there that you don't even look at those things to do? So yeah, there are some hey Derek, welcome back. So yeah, those are some things that like I'm like, okay. Like, okay, well, what do we do with that? Okay, let's see what we have here. Let me see. Oh, I did not mean to do that. Oh, wait a minute. That made that too big. Let me pull this back out. You know, that'd be one good thing about when you get to watch the motion hearings, because when we watch the motion hearings, we are able to see what evidence, you know, came in and what didn't. So let's go back to our last hearing that they had in order to find out what the judge is deciding. Let me get this on the screen. Sorry, guys.
Motion for review. There was a proposed order with the Commonwealth's motion. I don't think I got.
Wait a minute, it's not giving me no sound. Let me start it over. Let's start it over. Stop. Stop. Drop. Shut them down. Open up shop. Oh, no.
A proposed order from the homeowner, and I think he was invited to propose one, but I haven't seen anything.
I don't hear
so
anything. Wait a minute.
Commonwealth
Try it
A.
again. You said, what song is that? That's DMX. That's DMX. Oh man, I don't even know what is it? I don't. Do I know the song name? I don't know the name of the song. I just know the words of the song. Yo, that's DMX. I want to say, I don't know if it's Rough Riders Road, but I know that ain't the name of the song. They're like, stop, drop, shut them down, open up shop. Let me see. That's how Rough Riders roll. I don't know. I just look. I just know the hook. You heard the judge talking? I couldn't hear the judge talking. Okay, let me try it again. Sorry. It's called Rough Riders. There we go. SD got us. I have no clue. I'll just be singing stuff. And thank goodness Jason not here, because Jason will tell me I got the words wrong anyways. So there you go. Because I'll get the words wrong too. I'll be making up my own songs.
What's your position in regards to it? Was your order, but what is your thoughts in regards to that?
Well, I was approaching it as most of these types of cases that I do. We usually let the homeowner know when we'll be there. They make sure they're out of the home and it's unlocked. We go in. A case like this where we have 18 jurors, maybe send them in groups of 4 or something along those lines to see whatever myself and defense counsel want them to take note of, and then leave the premises with an instruction to the jurors they're not to open any closets or anything like that or touch any personal items. And I think that's pretty much what's encompassed in the order, if I recall.
Yeah. Mr. Reddington?
I have no position on that, Your Honor. Your Honor knows that I indicated I don't think it's necessary to have the view plus videos plus photographs, but I understand you've already made your decision on that. So it's a house that is now occupied by a man and his partner. It does not look at all like it did before when Lindsay and her family was living there. So I defer to your discretion on any specifics on the view.
All right. So my intention would be to, as I said, allow the motion for the view, issue that order in line with the proposed order that was given by the Commonwealth, and then as we go forward, we can give the homeowner a notice on that. We'll have police and security there to address any of those concerns. In the order regards to the media, we'll also deal with the no photographing of the jury during the view.
Could I just make an observation, Your Honor?
Sure.
It's a situation where obviously we're dealing with people that are civilians or professionals. This is not a situation where we're looking at a drive-by murder in the middle of an inner city where there's danger to jurors and stuff. Can I ask that the court at least limit the police presence? I mean, I have had it with police officers on motorcycles buzzing back and forth next to the jury bus, and police officers stopping traffic and blue lights behind you, blue lights in front of you. There's no need for that type of a police presence in this case. We're going to take a bus to a house in a residential area in Duxbury, and that's it. I understand that there may be a need to, I guess, I don't know, close down a road or something, but I would ask that we don't have such an overwhelming police presence for obvious reasons.
Come on.
We could go to sidebar. We do have a plan in place, but for security purposes.
Sure, yeah. You see it, sidebar? All right. One of the I know motions that was filed and argued had to do with photographs. I know, and I allowed the Commonwealth to be able to introduce some photographs. Just so, again, there's no surprises. If the Commonwealth can provide me a copy of the photographs that they intend to introduce, so I can look at them and make sure, no surprise, but would be in line with the ruling that we talked about.
Are you referring to the autopsy photos, Your Honor?
Whatever photos, or the crime scene photos, perhaps.
We could provide you with either the disc with all the photos, or it's the issue. The reason I'm hesitating is at the moment, as we're prepping, we're deciding what photos to use, but that could change mid-trial. So I could give the disc with all of the photos for you to review and be prepared in case there's an argument about one of them.
I don't think there's going to be. We've already kind of had the argument in regards to photographs, and I also allowed that some photographs will be admitted with limiting instructions, but I just kind of want to make sure that I understand really what the jury's going to look at, so I can make that final determination. So kind of however you want to do it. If you want to give me all the photographs, that's fine, or just some representative ones. I'm not going to hold you to if there's one that's a little different angle from some other one, but just so I have some idea kind of what we're going to have to deal with.
And I can bring in copies of the autopsy photos as well.
Okay, that's fine. All right, thank you. The other thing we had talked about last time was that the 3D model was, I'm not sure if that was done or if that's an issue now, or.
It's almost complete. I'm expecting to, Sean Marucci from our office has been working on that, and as soon as it's done, provide a copy to defense counsel in the court to look at. But it's going to be a digital monitor that's on the screen.
So it's a digital representation of the house?
Yes, a digital model of the home. It'll have an exterior view, and then it'll have each floor of the home. And it's just a digital model, nothing physical.
All right. So if you could just make sure Mr. Reddington sees that copy, and then we can deal with that as we come close.
I'm sure they will. I have no problem with the AutoCAD stuff. I may have one myself.
Okay. All right. So we won't worry about that. The blood spatter motion, we're going to take that up later. What other issues do we have? I know that there's one in regards to some additional witnesses, but besides that, Any other issues we need to take up?
The Commonwealth sent Defense Counsel several proposed stipulations. It would be helpful to resolve those.
I haven't had a chance to look at them yet, but I'm sure that I'm more than likely going to agree with all their stipulations, because if it's to avoid having people, in a ministerial sense, like somebody looked through a scanning microscope and they handed a slide to somebody else that put it in an envelope and somebody else looked at it. I have no problem with that. I'm not, as you well know, we've indicated that the mechanics, if you will, of the homicides and the actual event itself, we're not contesting. This is why you've already heard me complain about the autopsy photographs and all the gruesome stuff we're going to have to live through. But as it relates to their stipulations, I'm more than willing to stipulate to avoid having all these witnesses.
And just so the court's aware, they are witnesses, as defense has described, mostly laboratory witnesses. It would save calling 31 people.
Yeah.
So.
All right, and that's kind of what I figured was coming. So that's, I'll anticipate that there's going to be a fair amount of stipulations that'll be done. I'm not going to hold anybody to it at this point till we get the specific language in it.
My only concern is that in light of Commonwealth versus Gordon, I think there needs to be a colloquy with the defendant about the stipulation. And I haven't done one myself, so I don't have a model for the court. I'm not sure if other judges have done it at this point, but that's something, I think it would be something along the lines of other similar waivers of a constitutional right, but.
When someone stipulates to an element.
Right.
Yeah, so I'll either borrow one or draw one up. So I think that's a good idea. All right. I know that there was still a couple of remaining discovery motions that were kind of floating around. Do we need to address any of those, Mr. Reddington?
Are you referring to defendant's motion for relevant discovery?
Yes.
Okay. For the record, I would note, we're on paragraph 1, I'm looking for automatic mandatory discovery. I believe the government has been very effective in providing me with discovery. I mean, when there's a witness that's interviewed, they send me a copy of the interview. If there are notes, they send me copies of the notes, so I don't have any problem with that. I don't believe that there are any unusual issues that have been flagged on this motion, and I would ask if the court would entertain allowing paragraph 3, which is potentially exculpatory evidence, only because I know the case law, not that I doubt that they would provide me with exculpatory evidence, but I believe I have to have a motion allowed for the record to have it in play as far as the government's obligation that they recognize, and I respect the fact that they do, and expect that they would, but nevertheless, I would ask that you allow motion for exculpatory evidence, as well as motion for statements of the defendant. And again, I don't anticipate that there are extensive statements of Ms. Clancy to law enforcement. I don't believe there are literally any. And I'm well aware I have the discs of the government's doctors interviewing her, so I've already got that, but I would ask that you allow that motion as well.
Commonwealth?
So if I'm understanding correctly, from this motion, defense is just asking for the allowance of paragraph 3 and then any statements of the defendant, is that correct?
That's correct. Yep.
So I have no objection to statements of the defendant. We've provided those, and if any come to light, we will of course turn those over, but I don't expect any. In terms of paragraph 3, my concern with paragraph 3 is the last paragraph, the last couple of sentences where it says the new Rule 14 also requires the Commonwealth to inquire of each witness, officer, and agent and agency as to whether they know of or possess any exculpatory evidence. And then that last sentence, the defendant requests this court order the Commonwealth to produce each and every inquiry and each and every response.
I would narrow that, if I could interrupt you, I apologize. I would narrow that to, in the event that there are statements that disclose exculpatory evidence, the government would then advise the defense. They don't have to notify me of every single person they've talked to.
Well, so I made a note of that. I was wondering the definition. I'm going to make a suggestion. Maybe if the three of you can kind of come to an agreement as to that language.
Yes.
And then I'd allow that as to make the endorsement that reflects the actual agreement instead of just kind of a blanket one that the parties may later disagree with what was meant. So I'll allow that pending the proposed language. All right.
So that would just be paragraph 3.
Paragraph 3, and also regarding the statements of the defendant.
Which I don't think is its own paragraph in here, is that correct?
I'm sorry? What?
Statements of the defendant, is that a specific paragraph in your motion? Or
It
just
would be,
general?
yeah, just it's statements of the defendant in general, yes.
In general, okay.
Yep.
Okay. All right.
And no further action on the rest?
Right.
As of now?
Yep. All right.
Your Honor, there is a discovery motion filed as well where it's a request for a 17B2.
Yeah.
Looking for state police troopers, local police detail to sit at defendant's hospital room. Government has provided me with, today, a large number of duty assignments and records and documents. I believe they're going to provide me with the state police, but I would say that that motion can be tabled.
All right. So I'll take no action on that. I think that's pleading number 113, rule for motion discovery under 17B2.
Correct.
All right, so there'll be no action taken on that.
Okay.
All right. And then I think the only other kind of issue that we need to take up is the defendant's motion that was filed.
No, there are a couple more.
No, there are. Sorry.
Yeah, very briefly, Rana, as counsel had already indicated, on the document titled Joint Pretrial Memorandum,
Oh, yeah, okay.
the government sent an agreed statement of facts to be read to the jury, basically alleging on January 24th, 23, the defendant strangled her 3 children, naming them and their ages, with exercise bands in the basement of their home, thereby murdering them with deliberate premeditation and extreme atrocity and cruelty. And that's the extent of what would be referred to as the agreed statement of facts by the government. I then submitted a request that Your Honor would consider adding paragraph that Lindsay Clancy denies the allegations that she is guilty of, quote, murdering them with deliberate premeditation and with extreme atrocity and cruelty, end quote, and notes that she has accepted responsibility for the acts resulting in the death of her children, however, was lacking criminal responsibility at the time of the acts as a result of postpartum depression, psychosis, and involuntary intoxication. As a result of ingestion of numerous prescribed medications, Lindsay Clancy is thereby alleging she is not guilty due to a lack of criminal responsibility and will present what is referred to as the insanity defense, which I know was one of the questions that you had put in the questionnaire.
Come on.
So, Your Honor,
Mr. Reddington, do I have a copy? Is that submitted?
I mean, we send them all to the
I
court.
provided a copy of the joint pretrial
I
memo to the
have
clerk.
the joint pretrial, but I'm just,
The statement of facts is at the beginning, the proposed statement of facts for the Commonwealth.
I was looking for Mr. Reddington's version.
Because I know I sent them to them, I know we sent them to the court.
All right. All right. Yeah, go ahead, Ms. Brigg, I'm sorry.
So the Commonwealth would object to the paragraph as a whole. We would not object to the statement, Lindsay Clancy denies the allegations, and that she is alleging she's not guilty due to a lack of criminal responsibility. But the rest would have to come in either through her testifying or other witnesses testifying, saying that she denies the allegations that she's guilty of murdering them with deliberate premeditation and extreme atrocity and cruelty kind of flies in the face of the statements earlier that what happened is not in dispute. So that is the reason for having the evidence about what happened to Cora, Dawson, and Callan, and including the autopsy photos, because that all goes to extreme atrocity and cruelty and deliberate premeditation. And then the rest where it notes that she's accepted responsibility, again, that would be putting evidence before the jury or statements before the jury that may or may not ever be in evidence. So I think the standard, she denies the allegations, and then including what the defense is, which I usually object to, but I'm not in this case because it's public knowledge. So those 2 statements I think would be sufficient, and I don't think the rest would be appropriate.
All right. What I've done in past cases like this, I think the one we did a couple of years ago, was basically in the statement of the case after with the Commonwealth's allegations to say something about The question before you will be whether or not Ms. Clancy was criminally responsible if she lacked criminal responsibility. The prosecution has the burden of proof. The prosecution must prove beyond a reasonable doubt that she was criminally responsible at the time that she killed her 3 children. Any objection to that?
I do object to giving an instruction such as that, in that the case law states that we're not required to prove that she had criminal responsibility until the defense raises it. So at that point, at the beginning of the case, it hasn't been raised. I'm not objecting to it that that's her defense, that she lacked criminal responsibility, but I object to an instruction at the beginning when that evidence hasn't come in. I expect it to come in, but things change during trial. You never know. It's the same as with self-defense instructions. I object to those at the beginning of the case because it's dependent on evidence that comes in during the trial.
But then what's the basis then for asking the jury in the impeachment questions about their position regarding the defense of criminal responsibility?
Because like self-defense, we expect that will be an issue. So we want to know if it's going to affect our ability to be fair and impartial. But I don't think the instruction comes until it actually becomes an issue. And I understand it's the court's discretion on that issue.
Yeah. I'll take a look at them. But just so everybody, I'm probably going to give something similar to what I gave, what I just kind of read out, just to kind of tell them this is the issue. You know, this is the defendant's position that she was not criminally responsible. This is the Commonwealth's position, is that she committed a crime. And so it'll be something along that line. And I'll show everybody before we read it to the jury, so everybody can kind of have some additional feedback. But it'll be something similar to that, I bet. All right. What else? Any other issues before we get to the?
I did file a request for the court to consider, I don't know if you have it, the motion for sequestration of the jury. You didn't have that?
No.
Okay.
Have you seen this, Commonwealth?
I have, Your Honor.
Like I say, I know that when we file them, we send them to the DA, we send them to the court, so.
No, I have to follow my sword. It was sent to me. I had seen this one.
So the motion's left?
No, but I'd like to, just so I don't blame somebody else. It was sitting on my desk. All right, well, Ms. Ray, I'll hear you on this.
Thank you. Your Honor, basically can be very brief. This is, as I indicated, a very unusual case, emotionally, factually. Government's estimating 6 to 8 weeks for a trial, maybe less with the stipulation. Nevertheless, it would be a huge imposition on jurors. There has been extensive pretrial publicity, as you know, from the motion for a change of venue, which Your Honor heard and denied, which would be renewed at the time of the impanelment, depending on the way the jurors react to the questions in the sidebar individual voir dire. So my concern is that with all of those issues, and I understand that it's unusual nowadays, we don't really do sequestration of jurors. I think this is a very unusual case that may warrant that. And even if it's a possibility during the course of the trial, I think that the court should at least flag that issue for the potential jurors, for them to factor that into their own determination of their availability. So that's why I filed the motion.
Commonwealth?
Your Honor, Commonwealth objects to the motion. I think that the court will instruct, well, I know that the court will instruct the jurors not to go on social media, not to read about the case, not to pay attention to any of that. In addition, the court typically asks the questions every morning. If they've been able to follow those instructions, they're presumed to follow those instructions. So I don't think sequestration is necessary, and I don't think it would be necessary to ask them about something that may never happen in the case at impanelment.
All right. I'm going to deny this. I will, I'm going to ask the jury if they've heard of anything before, if it's affected their ability to be fair and impartial. I'm going to ask them every day whether or not they've seen anything, and also go instruct them not to view any articles or social media in regards to this during the course of that, and I'll follow up every day to make sure that they follow those instructions. So I'm going to deny this motion.
Do I have to note an objection every time you deny a motion?
No, I think my denying it is to
Thank
say
you.
that.
And I think there's one more motion you have.
All right. Okay, yeah. All right, what's the last motion?
Last motion, Your Honor, before we get into the jury questionnaire, I think would be caption defendant's motion for jury instruction. You have that?
I don't have that. Yeah, keep it down.
And I can give you this if you don't have it, it's all right.
Oh, you have a copy?
Oh, I know, it's here.
Your Honor, when you give the instructions to the jury on the law after we've picked the jury, and I believe you do it before openings, in light of the fact that it's obvious that lack of criminal responsibility is the defense, is the central bedrock of the defense in the case, I would ask that the court would, in addition to instructing the jury, as you do in a generic sense, about proof beyond a reasonable doubt, that the court would also instruct the jury that as it relates to the burden of proof, in the unusual situation where you're dealing with lack of criminal responsibility, that it is not the defendant's burden to prove that she was lacking criminal responsibility, but in fact, upon presentation of evidence, it's the government's burden to prove beyond a reasonable doubt that she was not acting as a result of a mental disease or defect. So I'm just asking that you would add that to the generic instructions.
Como?
Your Honor, similarly to the argument that the Commonwealth was objecting to the criminal responsibility being mentioned in the statement of facts, we would also object to the preliminary instruction, full instruction about criminal responsibility, because as my sister said, it is the defendant still has to raise it, and they have to raise it not just by saying it in an opening statement, they have to raise it by expert testimony, lay witness testimony, or the actual facts of the case. And so that isn't done until the case is underway, and preliminary instruction it comes well before that. So that is relying on Commonwealth versus Santiago, 485 Mass 416, a 2020 case that reiterates the instruction isn't necessarily need to be given in a preliminary, or in that case, it was actually for jury instruction at the conclusion of the case if the evidence wasn't raised. But I would suggest that the idea is even stronger, that if we haven't even presented the jury with anything, then they shouldn't be preliminarily instructed on it. If Your Honor was inclined to give it, because it is a discretionary thing, I would ask that you stick to the language of the model and not how counsel phrased it, because as you're familiar, the actual instruction when it comes to what the Commonwealth must prove with a criminal responsibility issue is not just whether we can say that they don't have a mental disease or defect, because the evidence may show that, but that is not the requirement for the jury. If there is a mental disease or defect, then the Commonwealth has to prove the other two prongs of the criminal responsibility statute. So the way it's phrased in the motion, I'd ask you not adopt that language and that you stick to the model if you are inclined to offer it, but we would object to the giving of it.
What if I instructed the jury in a sense, almost like hypothetically, that it's anticipated that the defense of criminal responsibility is going to be raised? If that's raised, this is what the law is.
Well, I would suggest that we don't want to be caught in a burden shifting situation on a preliminary instruction, so maybe that language is a little bit too close. I think it's either Your Honor gives it as it is in the model in the preliminary as a preliminary instruction, or it's not to be given and just to be addressed at the conclusion of the case.
Right. I generally give it. I understand the Commonwealth's position, but I generally think it's a good, well, I'll just leave it at that. I generally give that, so I'll take a look at, but I generally give the model language that's suggested. All right.
I think that concludes the motions.
All right. And then there's one last motion that was filed yesterday. Did Commonwealth have an opportunity to review that?
Your Honor, I briefly looked it over. I would suggest that we shouldn't even broach this motion in that it violates Rule 14 discovery and that these individuals have been identified by initials only with no other information, no statements of the witnesses, no indication of what these witnesses have to offer or the background, and it's 1 week prior to trial, so I'd ask that it just be denied on its face.
Well, I understand that, but it's been raised. So I'm going to hear from the Commonwealth, and I'll hear from the defendant first, then from the Commonwealth. I'm sorry, and then I may have to take it under advisement myself, and it may be the argument that there's just not enough here for me to make a decision is there. But I think I want to give the defendant the opportunity to argue this. So, Mr. Reddington, this is the motion to eliminate to permit testimony from witnesses who have themselves been, according to the motion, victimized by the medical system regarding the issues of postpartum depression and postpartum psychosis.
Yes, Your Honor, thank you. Your Honor, as I say in the affidavit, and as you can well imagine, I have been contacted by many people who have, in a very moving, emotional fashion, advised me of these horrific issues that they've been dealing with postpartum depression, postpartum psychosis, hearing the auditory commands, having intrusive thoughts to hurt or kill their partner or their children, infanticide, as a result of postpartum psychosis, medication issues, contributing to the postpartum depression, postpartum psychosis. And it's so easy for us as a society to say in a troubling case like this, oh my God, she's guilty, throw away the key, put her in jail and just be done with it because it makes everybody feel better. It's a feel-good reaction that, okay, somebody has been punished because of doing a very bad thing. But as we know, when you're dealing with the issues of lack of or a disease, and they have actually experienced something that is so outside the ken, if you will, of jurors, of normal people, for us to believe that somebody's hearing voices.
Those cases develop, I'm sure Mr. Reddington may remember, as those cases that became more and more admissible, it really hinged a lot upon the testimony of experts. And in this case, I anticipate there's going to be experts that are going to talk about the reality of this postpartum depression and postpartum psychosis. So that's coming out. And these are testimony that will come from the experts, I think, on both sides. It doesn't seem like there's a question of whether or not postpartum depression or psychosis is real. I mean, all the experts seem to agree that it's real. So because of the ability to get the probative part of what those women would bring to the court, the experts can give that. And so I'm going to deny the motion at this time. All right. Anything else we need to address, Commonwealth?
I just think on the questionnaire, I was looking over the questions. I don't have any objections. I only request an addition. On number 2, it asks about a family member or close friend being diagnosed with postpartum depression, or generalized anxiety disorder. It also asks to include bipolar disorder, as most of the experts in this case have diagnosed the defendant with bipolar disorder. So I think it'd be important to have that information.
All right. Anything else in regards?
And also, Your Honor, there's no question on here regarding medications, whether people have any experience with psychiatric medications and whether that would affect their ability to be fair and impartial, either experience or views about. Is that the case?
All right. Mr. Reddington?
First of all, if I could just harken back to the orders that you've given on the motions in limine, and I don't mean to seem paranoid, but you, I'm sure, understand. The appellate courts in Massachusetts have repeatedly stated that on a motion in limine, if the defense counsel does not object, you're waiving it. So I just want to make sure, number one, for the appeals court, if necessary, or the SJC, I object. And is it my understanding that any further objections, I don't have to keep objecting because I respect your ruling that I don't have to?
Come on. I have no problems with that. I think it's clear that the issues were raised on the motions to eliminate. I've ruled on them, and I think there doesn't need to be a recurring objection on those.
I would agree, for the record, Your Honor, that if whichever party was affected by the denial, the objection is there.
Okay. All right.
All right, addressing the questionnaire, Your Honor, if I may, it's an interesting issue that we're dealing with. The questions that have been requested, have you, a family member or close friend, ever been diagnosed with postpartum depression, or generalized anxiety disorder? The next question is, skipping over the NGA, number 4, have you, a family member or close friend, ever been diagnosed and or treated for mental illness or condition? And then going down to number 6, have you, a family member or close friend, had an experience with a psychiatrist, psychologist, or mental health facility that would make it difficult for you to be fair and impartial in this case? And finally, number 9, do you believe that a person's mental illness should not be considered when determining their guilt or innocence? So, going backwards, number 9, this is very similar to when we ask jurors or we tell jurors, do you understand that a defendant does not have to testify in this trial? Do you understand a defendant does not have the burden of presenting evidence on his or her own behalf? And many times at sidebar, jurors will say, well, I think they should tell their side of the story. And then the judges will say, well, if you are instructed by me that that is not to be considered, can you then abide by my instruction and be fair and impartial? And they always invariably say, well, yeah, I could, I guess. And then they will be accepted. I'm concerned about raising all of these so personal issues. There is a stigma in this country of mental disease or illness. There is, whether we acknowledge it or not, and it's embarrassing to many people. And I'm just concerned that jurors would, let's say they answer yes to question 2, that you or a family member has been diagnosed with PPD or depression or generalized anxiety disorder, and they say yes, then that's going to open up the inquiry into when, where, how, who, what medication, and will then invariably lead to kind of an inverse challenge by repeated challenges by the government, I think, to pretty much any citizen who comes in here. It's almost like a reverse Batson challenge. Any citizen that comes in here and has had mental treatment or has had what they perceive to be a mental disease, and they have been on medication, they're going to say hypothetically, yes, I have, and I saw Dr. So-and-so, and I think that the shrinks are useless, and I think they're terrible, they're horrible, and they ruin my life. They're gone. They're going to challenge that person. If a person says, I had treatment, but my psychiatrist was on medication, that begs the question, how did that work out for you? Was there any issue with the medication? Anyone that has any issue whatsoever with mental disease, defect, or medications is going to be tossed because of alleged cause. They're going to say it's for cause because they have a preconceived notion. That's going to wipe out a significant number of citizens that are being brought here to this court to sit on a jury, recognizing the fact that the issue of mental disease, defect, treatment, lack of criminal responsibility is central to this case. I certainly have no problem, and I have confidence, as we always say, that the court will give a very forceful instruction to the jurors that regardless of any preconceived notions, that they come into this court with a clean slate and they have to listen to the testimony and listen to the evidence. We do it all the time, usually to the detriment of the defense, but we do it and we say, okay, can you understand what I'm telling you, that you don't have to listen to this, or that you don't have to feel the defendant has to present their evidence, and we accept them as jurors. So I don't think it's fair to exclude a potentially significant number of people that would be good citizens, good jurors, just because they have had mental disease or treatment, psychiatrists, psychologists, MDMA, or whatever they call it, or any of those treatments, or medical issues with medications. I just think that we're flirting with disaster on that type of question.
So what would you want me to just ask number three?
Number three, looking at number three, I think is fine. The defense in this case is that Ms. Clancy is not guilty due to not being criminal or lack of criminal responsibility at the time she killed the 3 children. This is commonly referred to as an insanity defense. Is there anything about this so-called insanity defense that would offend you or cause you to not be able to fairly decide this case? And then they come up on the individual voir dire and they say to you, in our presence, yes, I don't like psychiatrists, or I don't like psychiatric medications, or my brother did something or other. Yeah, I think question 3 captures it, instead of going through all of those questions, number 2, 4, 6, 9. I think number 3, I have no problem with.
Commonwealth?
Your Honor, I think the questions should remain as they are. Defense counsel's only objection to them seems to be his belief in knowing how we're going to make decisions and how we're going to address issues or answers that come up at sidebar. And he is wrong about our approach, and he is wrong about the way we handle things. I can speak for myself, and I can say that if a person comes up and says that they have had mental health treatment, mental health medication, I have no issue with that, as long as they can be fair and impartial to both sides. And I mean both sides, not just me, to the defense as well. Now, his example that he gave, that someone says, I had an awful experience with a doctor, it ruined my life, and I can't be fair and impartial, I should think that neither side would want to take that person, because we want a fair and impartial trial for both sides. So I think the questions are fair. I think the questions get to the heart of the issues that will be in this case, and I think a lot of them get to the issues that case law in this area addresses we should ask about. So I'd ask that you leave your questions as they are.
All right, I'm going to take a look at it. I don't think I'm going to go just with 3, but I may combine. There are a couple of kind of just going over the same kind of area. So I think if I can condense those, that's probably what I'll do. And I'll give parties the chance to be heard again in regards to that. So it'll probably be 3 and then maybe one other one addressing that kind of issue. All right, anything else?
Would you want to consider adding the question of Do you understand that a defendant does not have an obligation to present any evidence or testify in the
I'm
case?
just so everybody knows, what I'm also going to do is after we have the questionnaire, I'm going to bring them up, bring each juror over to the side, and then I'm going to ask, some additional questions, including defendant not having to testify.
Okay.
And understanding not having to present any evidence.
Yep, that's fine.
Questions about police credibility, all those type of things that I would generally ask. I was just having the questionnaire because these are kind of issues that those type of questions in the questionnaire, it may be easier for people to go and kind of reflect a little bit instead of just standing up here for the first time, being hit with these type questions in front of us. So I will ask, defendant does not have to testify. The defendant has no obligation to present any evidence. The police credibility question, kind of things along those lines, I'll ask over here. And then the parties can have, reasonable follow-up as well. All right?
Thank you.
Anything else?
Finally, you gestured to that side of the bench. Would the individual voir dire be?
The individual voir dire, that's just by force of habit.
Okay.
The individual
I was gonna
voir
say,
dire,
we
as we
need that.
discussed before, will be
Yep.
done over here.
Perfect.
Defendant will be here, sidebar.
Okay.
And then, and that's part of why we're going to take that break, to have the jury go back, fill out the questionnaire, then we'll set it up for the individual voir dire. We'll do that over here.
Okay, thank you.
Okay? All right. Now, anything else?
Not for me.
All right, come on. All right, well, thank you very much. We'll see everybody on Monday, 9 o'clock. We'll begin the impanelment. As you know, it'll probably take a little while before we get the jury up here, but so if there's anything that we have to address before I go talk to the jury, we can do it then. All right? All right, counsel, thank you.
Thank you.
Yeah. We'll do the other one, yeah.
Court rise, please. Court is in recess.
Okay, so I am going to show, so that's kind of how they came up with the jury questions and things of that nature. So from my understanding, guys, like yesterday when they were trying to see some people from the jury panel, through the first questions, like there are a lot of people that even raised their flag saying that they knew somebody. Like we got 182 witnesses, which is a lot of witnesses. So a lot of people just didn't even make it through the first portion of a lot of this stuff. So we got to get a good insight in regards to how they were going to ask the questions and things like that for the jury. Yes, the defense was also trying to get in some postpartum witnesses to testify, but I think that's like subjective, depending on what your postpartum depression is or disorder. So I don't know if somebody else can testify, but so the judge did deny that part of it, but only because, like I said, I did not follow this at all. I am going to take us back to right after the incident happened, because I would like to see what evidence they actually show, like kind of like the grand jury of things. Just so I can I just would like to see. I mean, we'd be nosy. It's here, so why not watch it? So this is the arraignment, guys. So let me put this up here. Let me change the thing that we have on here, and then I'm gonna play her arraignment real quick because I want to see what is this about. Let me see. I mean, this got to be a messed up feeling. Like, in some ways, I'm like, okay, she probably, she probably has, I want to say in way, like, I'd be feeling like, okay, she might have suffered enough. Like, you got all 3 of your children are passed away. You had the most unsuccessful attempt at unaliving yourself. Your husband, who, if you saying that y'all had this loving, wonderful, blissful relationship, and everything just spiraled out of control from these D-rugs, prescription D-rugs, that is. Like, oh my gosh, can you imagine now having to like deal with this every day? Like, the amount of depression that she got to be going through at this point in time cannot be anything compared to what she was going through then. Like, oh my goodness. Like, that, I'm like, oh my God. Sometimes I feel like, okay, maybe she didn't suffer enough, because this is like, like, I don't even know. I don't even know how you deal. And the way, you know, he probably, you know, his relationship, unless this lady was around before the end, I'm assuming that he, you know, his new confidant, or, you know, his new wife and his new family is allowing him to kind of like get past some of the stuff or work with some of the stuff. Because sometimes I'm looking at him like, I don't even know how he's doing it. But let's see what we have here, because like I said, I've never seen it, so any of her stuff, so I'm watching it in real time with you guys. Okay, here we go.
Has a complaint charging you under 265 section 1, count 1 murder, juvenile 1. Count 2, 265 section 1 murder, juvenile 2. Count 3, 265 15D big A, strangulation or suffocation, juvenile 1. Count 4, 265 15D big A, strangulation, suffocation, juvenile 2. Count 5, 265 15D big A, strangulation or suffocation, juvenile 3. Count 6, 265 15A big A, assault and battery, dangerous weapon, two-way exercise rope, juvenile 1. Count 7, assault and battery, 265 15A with a dangerous weapon, two-wit exercise rope, juvenile 2. And count 8, 265 15A, assault and battery, dangerous weapon, exercise rope, two-wit, juvenile 3. Ma'am, the plea of not guilty will be entered. Please be advised, while this case is pending, any violation of state, federal, or local law may result in your bail being revoked and be held without bail.
Commonwealth, I'll hear from you first.
Thank you, Your Honor. The Commonwealth is requesting that the defendant be held without bail based on the facts of the case, the strength of the Commonwealth's case, and the potential penalty. On Friday, January 27, 2023, using an erasable whiteboard because she was still temporarily intubated, one of the first questions that Lindsay Clancy asked was, "Do I need an attorney?" She knew that she had murdered her children, and she had the clarity, focus, and mental acumen to focus on protecting her own rights and interests. The following is a summary of the events that led to the murders of Cora Clancy, Dawson Clancy, and Callan Clancy. On the morning of Tuesday, January 24th, 2023, the defendant took her 5-year-old daughter Cora to the pediatrician's for an appointment. She interacted with a receptionist, nursing staff, and a doctor. There were apparently no issues with the defendant's demeanor or behavior, as she completed the appointment and was allowed to leave with Cora without any issues or concerns. When she returned home, she went outside with Cora and her 3-year-old son Dawson to play in the snow. They built a snowman. The defendant sent photos to her mother and to the defendant, to her husband. She texted with them. Nothing in the text was out of the ordinary or any sign of any distress or trouble. Back inside later that day at 4:02 p.m., the defendant searched on her phone Kids Miralax. She then searched at Takeout 3V via her cell phone at 4:13 p.m. Immediately after doing that, she used Apple Maps on her phone to determine how long it would take someone to drive from her home in Duxbury to 3V restaurant in Plymouth. So she would know how long someone would be gone if they ran that errand. She next went on the CVS website at 4:47 p.m. and then called CVS on Summer Street in Kingston. She spoke to the manager of CVS and asked if they had the Kids Miralax. The manager told her no, but they had other similar medications. According to the manager of CVS, her voice did not sound slurred or impaired in any way. She had no trouble understanding the defendant, and it was a perfectly normal conversation. At 4:53 p.m., the defendant texted her husband, who was working in his home office in their basement. She texted, "Any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day." This was an unusual request, as when the family ordered takeout, they'd usually go somewhere closer to home, but it was a place that they had been in the past. Patrick Clancy texted back yes, and then the defendant asked him to check the menu. At 5:06 p.m., the husband texted the defendant asking what she was going to get. She responded, a Mediterranean power bowl. She spelled it correctly, and it was something that was on the menu. He then told her that he wanted the scallop and pork belly risotto. At 5:10 p.m., the defendant called 3V Restaurant to place the order. She got the order correct. She gave the correct name for pickup, Patrick. The hostess who took the call said there was nothing out of the ordinary about this call. She was able to understand the defendant, that her voice was not slurred or impaired in any way. At 5:15 p.m., Patrick Clancy headed out the door to run these errands at the defendant's request. As he left, she texted him Pedialyx liquid stool softener. Surveillance footage shows Mr. Clancy at CVS on Summer Street in Kingston at 5:32 p.m. He goes to the medication aisle, the children's medication aisle. Phone records show that he called the defendant at 5:33 p.m. and she did not answer the phone. She then calls him back at 5:34 p.m. and the call lasted 14 seconds. He's there at the store unsure of which medication to get, and she tells him exactly what she wants. He had no issues communicating with her. It was a completely normal call, although he did mention that she seemed like she was in the middle of something. He is on surveillance footage during this time, exiting that aisle and appeared to be using his phone. He then heads to the register, makes his purchase, and leaves the store at 5:37 p.m. He's next seen on footage at 3V Restaurant at 5:54 p.m. He picks up the food and he's out of there within a minute. When he arrives home, the first thing he noticed was the silence. He did not see or hear the defendant or the children. He actually called her cell phone at 6:09 p.m. looking for them, and she did not answer. He went to their bedroom on the second floor and the door was locked. He was able to open it, and when he looked inside, he saw blood on the floor in front of a full-length mirror and the window open. He immediately runs downstairs and into the backyard, where he finds the defendant laying on the ground. She appeared to have cuts on her wrists and neck, but he stated to 911 that those wounds were no longer bleeding. She was conscious. He called 911. During this time, he asked the defendant, "What did you do?" She responded to him, "I tried to kill myself and jumped out the window." During the 911 call, Patrick can be heard asking the defendant, "Where are the kids?" He later told police that she replied, "In the basement." So immediately after this happened, she knew what she had done and she knew where the kids were. When EMS arrived, he asked them to stay with her so he could go find his kids. The 911 call kept going. Patrick can be heard on the 911 call entering the home and heading to the basement. At one point, he calls out, "Guys." He can then be heard screaming in agony and shock as he found his children. His screams seem to get louder and more agonized as the time passes. Cora and Callan were on the floor in the den area of the finished basement, which is to the left when you walk down the stairs, while Dawson was alone on the floor in his father's home office, which is to the right when you go down the stairs. Each child still had the exercise band that was used to strangle them tied around their necks when their father found them. Dawson and Callan were face down on the floor. Cora was on her side with her torso turned towards the floor. He removed the bands and begged them to breathe. He continued to scream uncontrollably and screamed for officers to come to the basement. The dispatchers are hearing this and they send help down to the basement, and when they encounter Patrick, he yells out, "She killed the kids." The police rushed the children to ambulances that brought them to the hospital, and unfortunately, Cora and Dawson were declared dead at the hospital. Callan was med-flighted to Boston Children's Hospital. Medical staff was able to restart his pulse, but not his brain activity. He was placed on life support for several days before passing away. The defendant was transported to South Shore Hospital and then to a Boston area hospital where she remains. She sustained several broken bones in her back and her rib cage. The police were able to find several notebooks in the defendant's home pursuant to a search warrant, and also notes on her phone that were similar to journal entries. In the months, weeks, and days preceding January 24th, 2023, the defendant meticulously detailed her daily activities, her children's lives, her mental state, and her medication use. Her writing was clear, precise, and articulate. She never indicated that she was hallucinating, delusional, or had disordered thoughts or speech. In all of her writing, she appears to know who she is, where she is, the date, and with whom she's interacted. She wrote a note on her phone the day before killing the children, stating that she had, quote, a touch of postpartum anxiety, end quote, around returning to work. She wrote that her psychiatrist had prescribed medication to help her. The defendant was initially diagnosed, according to her husband, with generalized anxiety disorder. She was then evaluated at the Women and Infant Center for Women's Behavioral Health in Providence, Rhode Island on December 20th, 2022. There, after an evaluation, she was told in the presence of her husband that, by psychiatrists, that she did not have postpartum depression and that she had no symptoms of postpartum depression. She wrote in her journal that at times she had suicidal ideation in December of 2022, and she also told her husband that she had suicidal thoughts and on one occasion had thoughts of harming her children. But she did not write or voice those thoughts after a stay at McLean Hospital. When she had those thoughts, she consulted with a psychiatrist and with her husband, and then she committed herself to McLean Hospital on January 1st, 2023. She was discharged by the hospital on January 5th, 2023, and the hospital did not file any paperwork at that time attempting to have her committed as a danger to herself or others. She also kept meticulous and detailed daily medication logs in a diary that she wrote. She detailed that she had difficulties with each of the medications that were prescribed to her. And when she had issues with those medications, she detailed how her doctor had her stop that medication or wean off of it and then try something else. They were trying different medications to see what would work for her, what would benefit her. According to her husband, she was never on more than 4 to 5 medications at one time. And at the time of the murder, she was taking only 3 medications. And he said to the police that she always took the medications as prescribed. After her stay at McLean, the defendant appeared to be getting better, according to her husband. She slept well, interacted with friends and family. She went out with her kids and husband to places like the Kingsbury Club in Duxbury, the Charlie Horse Restaurant, the Museum of Science in Boston, the Cape Codder down the Cape, interacting with her family and the public without any apparent difficulties. She even stayed alone with the children on several occasions without any issues in January of 2023. Her husband asked her in mid-January, "Are you still having suicidal thoughts?" And she said no. The defendant's parents visited the family the weekend of January 21st, 2023. They interacted with the defendant in person. The defendant was able to run errands while her mom watched the children. She texted back and forth with her mother, and there was nothing out of the ordinary about these text messages. In fact, the defendant texted her mother on January 22nd, 2023 to ask how her ride home went. During this conversation, the defendant's mother wrote, quote, "Enjoyed seeing everyone this weekend. Nice to see you doing better," end quote. On the night of the killings, Patrick Clancy was interviewed by the police at Beth Israel Deaconess Plymouth Hospital. He told the police that the defendant was having one of her best days. She was smiling and happy, and there was no indication that she was going to harm the kids. No one at all described her as acting like a zombie in the days leading up to the murder or on the day of the murders themselves. On February 5th, 2023, this past Sunday at 1:35 p.m., while sitting with Dr. Paul Zeisel, the psychologist hired by defense counsel to evaluate her mental state, the defendant used Dr. Zeisel's cell phone to call her husband. She left a voicemail stating that she loved him. Yesterday, on February 6, 2023, at 10:09 a.m., she again used Dr. Zeisel's cell phone to call her husband. This time he answered, and during this call, the defendant stated that after he left the house that night, she killed the kids because she heard a voice and had, quote, a moment of psychosis, end quote. He asked her what voices she heard, and she said she heard a man's voice telling her to kill the kids and kill herself because it was her last chance. Patrick Clancy told the police the defendant had never heard voices before. He also told the police the defendant had never used the word psychosis to him before. The first time she used that word psychosis was when she was with the doctor hired by defense counsel and using his cell phone. The defendant actually wrote a note on her phone on October 25th, approximately 3 months before this happened, October 25th, 2022. She wrote, quote, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them, I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all of my kids." She then wrote that she wants to have more kids eventually. The children were killed by ligature strangulation. Ligature strangulation causes the victim to become unconscious anywhere from 10 seconds up to a minute. The more the victim struggles, the longer it takes. After the victim is unconscious, the ligature must be held in place with force, squeezing the neck for up to an additional 4 to 5 minutes to cause death. Therefore, she had to strangle each of them to unconsciousness and then make sure the bands were squeezing their little necks for several minutes. She could have changed her mind at any point during that time and removed those bands from their necks, and she did not. The defendant did not take advantage of the situation when her husband left the home that night. She created the situation, and she used Apple Maps to make sure she would have enough time to strangle each child before her husband returned from where she had sent him. The defendant is a danger to herself and others. She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom. She did so with deliberate premeditation and extreme atrocity and cruelty. And to supplement what the defense counsel has provided, I have a statement of bail argument to file with the court. And thank you, Your Honor.
Thank you very much. Attorney Reddington.
Thank you very much, Your Honor. Your Honor, my request is that the court not enter what I would suggest is an inhumane order, ordering this woman to be incarcerated. We all know, as people that work in the system, that jails and prisons are woefully deficient in medical care of the most basic type. We all know that this is an individual, as Your Honor knows from Dr. Raycard's letter, who is in dire medical condition. We all know that this woman is, as counsel concedes apparently, a danger to herself. I question whether she would ever make it to a trial. She's suicidal. She's extremely emotional. However, she's unable, and has been unable, to express any happiness or sadness or cry. And in fact, sometime about a month or two ago, she made the comment, "I just wish that I could feel something." Now, our society fails miserably in treating women with postpartum depression or even postpartum psychosis. It's medicate, medicate, medicate. Throw the pills at you, and then see how it works. If it doesn't work, increase the dose or decrease the dose. Then end up trying another combination of medications. We're talking a relatively short period of time from when that baby was born in October up until January, when this incident occurred, Your Honor, that she was on such significant dosage of medication. Your Honor knows that Cora was born in 2017. It was a very uneventful, normal pregnancy and delivery. No issues afterwards as far as anxiety. Dawson was born in 2018. Again, it was a normal birth. She had no significant issues as far as anxiety. She did have to have stitches and she was sore, and that was about it. Then, of course, Callan was born. When Callan was born, she ended up becoming depressed and suffered from significant anxiety, as a result of which she consulted with a number of doctors. A number of doctors indicated that she would be able to sleep, she would be able to feel, she would be able to emote once these medications kicked in. And again, as I say, our medical, in our society, completely abandons women with this condition. It's easy to say, come on, you have a healthy baby. You have a wonderful husband. You're able to take care of your kids in your home. You're lucky. Take the pills, you'll be okay. Well, they put her on a number of medications. They put her on Prozac, which Your Honor is well aware is known as SSRI, selective serotonin reuptake inhibitor. Your Honor knows that along with some of these medications, they have the black box warning from the FDA, may cause suicidal ideation, may cause homicidal ideation. She was on Ativan. She was on Benadryl. And then she ended up being told, okay, because she was complaining about the effects of the Prozac, they said, stop the Prozac, we'll find something else. They put her on Remeron. Then they added on Seroquel. And Your Honor, I attached from David Benjamin, the toxicologist, some papers with the submission, and Your Honor can see the side effects that this Seroquel causes. She was having bad thoughts. She was having worsening depression. Her husband suffered through that phase. Her parents were well aware of the fact that she was suffering from this depression and depressive phase. She wasn't sleeping. She ended up, at some point, Your Honor, December 31st, she was on Seroquel. They told her then the Valium would be stopped. She was a shell of herself, no personality, and went to the doctor again. The doctor again prescribes the Seroquel, and then they took her off the Seroquel. And then she went to the doctor, and at that point, they prescribed trazodone, Ativan, amitriptyline, right up to the very end, when she was so bad that she voluntarily turned herself in, if you will, to the McLean Hospital. We know that that's a psychiatric hospital. She was at the McLean Hospital for a period of about 5 days. While at the McLean Hospital, they basically tried to get her off the Seroquel. She wanted to get off the benzodiazepines. She felt that she was being addicted to the benzodiazepines. She then ends up on trazodone, Ativan. Her mood was terrible after she got out of McLean Hospital. She still had the suicidal thoughts. As the government has indicated, she even told her husband that she had suicidal thoughts. You think this is something that she's planning to kill these 3 kids by going and getting a menu, going on to Google Maps or whatever it is, and finding out the distance? When she tells her husband she's having suicidal thoughts, probably a month prior, thoughts of hurting her children, they go to the doctor again, and she's on the medications, on and off, on and off. This is a significant issue between the postpartum depression as well as possibility of postpartum psychosis that is pretty much ignored. But nevertheless, with the overlay of the SSRIs and the history, and Your Honor has some emails and things that people would reach out to me from all over the world indicating that their daughter had the same problem, that they had the same problem. Your Honor is well aware that many times when people are on Prozac or on SSRIs, workplace violence, homicides, family homicides. This is clearly a tragic, which is a word that's used too much in the criminal justice system, but this really is a tragedy, this case. So we have, obviously, I would suggest, a very good defense for this young woman. She's 32 years of age, Your Honor. She met her husband. He was the love of her life. They got married. Wonderful young couple, and as counsel noted, she always wanted to have kids, always wanted to have babies. She's a nurse. She went to be a midwife because she wanted to help other women that would be in having babies, but didn't want to have all the medications. She was not a big medication person. Your Honor saw, I think there's probably close to 50 letters that have been submitted to you, and I know you read every one of them. The incredible outpouring of support by other nurses that work at Mass General Hospital. The fact that these women have a vigil, that they write the letters to this court imploring you to understand that you sentence, as far as bail issue, the woman before you, who was a beautiful person, who was thoroughly destroyed by these medications. That's for another day, obviously. A bail issue, bail argument. Your Honor is well aware under Commonwealth versus Vasquez at 481 Mass 750, Supreme Judicial Court indicated that this court, or the court, has vested in sound discretion of the bail judge And the main considerations would be obviously the usual bail considerations: nature and circumstance of the offense, likelihood of success on the defense, roots in the community, and of course, as in Vasquez case, as well as Commonwealth versus Herring, 489 Mass. 569, defendant's risk of flight. So now you have a situation, Your Honor, where this woman has incredible support, as you saw, letters from Foxborough that were signed by about 15 women, letters from her family, friends, letters from people she's known since the 6th grade that have stayed in touch with her. One thing that's a theme that is readily apparent is that Lindsay loved her children, that she would always, one of the letters said, she would always rub her belly, rub her belly. She had pictures of her pregnant standing next to Patrick, hanging on the wall. I was in the house. The house is absolutely loaded with indicia of love for those kids. Photographs on the wall, little drawings, all sorts of games, toys, playpens, bassinets in the living room, in the dining room, the kitchen loaded with toys. Virtually the entire house, including their master bedroom. Toys, things for the kids. This is not a situation, Your Honor, that was planned by any means. This is a situation that clearly was a product of mental illness. Now, under the Vasquez case, one of the issues, as I said, is whether or not there's a risk of flight. Now, I did submit to Your Honor a letter that was written by her physician, her attending surgeon, Nakul Rekha. This doctor was in surgery until 8:30 at night and actually took the time to write this letter for you to review. And I just want to make note that he makes reference to the fact that she is now in her 12th day of hospitalization following admission on January 25 after a 20-foot fall. She suffered, unlike when the government Friday was saying that she can move her legs and she's getting better, she's okay. No, she's not okay at all. He indicates that she suffered several severe spine fractures, including spinal cord transection. You know what that means. At the level of T5, T6. As you know, she had surgery for this from the Orthopedic Spine Surgical Service, who performed a decompression infusion. Unfortunately, she is not expected to recover meaningful function at this point below that level of the spinal cord, which makes her a paraplegic, unable to move her legs or feel sensation from below her, he refers to umbilicus or belly button. He says she has no function below this level. Additionally, less active issues include rib fractures in the chest, both sides, cervical spine fractures, necessitate the wearing of a collar around her neck due to the cervical spine fractures. She's paralyzed. The doctor indicates that she needs significant medical treatment. Doctor recommends that she would be discharged to Spalding Rehab. Now, you know that we have Spalding Rehab. You know that we have the Worcester Hospital. This court is vested under Vasquez with your authority to have this woman not held on bail. Perhaps put a GPS on her, I guess, if someone's concerned that she's going to miraculously recover, which isn't going to happen. As your Honor knows, being a paraplegic, paralyzed, she can't move. Can't get off the bed. She can't walk. She can't even go to the bathroom. She has to have 24/7 medical care. Her emotional state is so bad that there's a significant fear of suicide. She has to have someone sit in the room 24/7 to watch her. They don't talk to her. They're not, chatting it up. They just sit there and watch out of that concern that she would commit suicide. So you have a paraplegic who can't walk, who is definitely a danger to herself, and the government wants to put her in where? Framingham State Prison? Plymouth House of Correction? There's no way that any humane person would do that, especially within the structure of our criminal justice system, where a person is presumed innocent. And I'm not suggesting with the facts that the government has read, but she has a good defense. She's got a darn good defense to this case, because that's what happened. And I just want to share with you, Your Honor, one of the things that's interesting. When I was in the House, I came across a drawer that had a bunch of pill bottles in it, and I called the DA and I said, I got these pill bottles, and made arrangements, I'm gonna be giving them to them. And it's all the Prozac and the Trazodone and all that stuff. But inside the drawer was this little vase. And I didn't know what it was, just looked like a little vase to me. And my wife said to me, oh, that looks like a wish vase. I said, what's a wish vase? She said, when people write down little wishes and they put little pieces of paper and they put them inside the vase. And there are literally dozens of these little pieces of paper that talk about Lindsay's wish for happiness and health for her children, that she could get pregnant again, that she would be able to be with her children, little Callan, Dawson, Cora, that they would be happy, healthy, and successful. This is not a woman, Your Honor, that had any reason to harm those innocent children. My request, Your Honor, is that the court would put her on a GPS if you feel that's required, and let the doctors continue to treat her. Let her go to Spalding Rehab. She will sign a waiver that allows probation at any time to speak with her treating physicians or social worker. Find out how she's doing. Does it look as though she's getting close to regaining the ability to walk, which she isn't, but nevertheless, they would be able to do that. And then the government would be notified, and they can come back in here again and try to hold her without bail, and my request would then be to Worcester for the emotional and the mental illness aspect. I don't think that it's fair or just or consistent with our duties to each other as human beings to put her in jail. I'm asking that she be allowed to continue with her medical treatment, Your Honor.
Commonwealth. Your Honor, if I may, I did look into medical treatment if she's held. We were under the impression we had received information before that she could move her legs, but then we learned updated medical information that she, for the time being, is paralyzed from the waist down. If she is held, she could go to the Shattuck Hospital. If Shattuck does not have what she needs, she can be sent to another facility, and the corrections officers would go with her there. Shattuck would actually work with her, the doctors at the hospital she's currently at, to determine the best course of treatment, and if whatever she needs, she's going to get. But as defense counsel said, she is a danger to herself, and from the Commonwealth's perspective, others. And just because she is paralyzed does not mean she's not a flight risk. She will be in a wheelchair eventually, and she can be driven somewhere, she can be flown somewhere. It does not mean that she will never be able to leave this area.
Just would like to say that
Sure.
Yeah, I'm sorry.
Go ahead.
Thank you. I have been, unfortunately, in the Shattuck Hospital. To suggest that she can get, quote, what she needs from the Shattuck Hospital is absolutely not true. The care that she's receiving at the hospital she's at now and the care that she would be receiving at the Spalding Rehab are light years ahead of the dismal, dank conditions of the Shattuck Hospital that we put our prisoners in. It's like something out of Iran, and that's not fair or correct.
Thank you both. Both of you, all of you who appeared before me that will be litigating this case are all very well respected, and I'm sure at some point in time in Superior Court, this case will be tried in a very professional and very well by both sides. As counsel stated in Commonwealth v. Vasquez, the Supreme Judicial Court addressed the issue of bail in first-degree murder cases, and Justice Lowy issued a detailed decision about the issues in these types of cases. The court found that a defendant charged with first-degree murder has no right to bail, but may be admitted to bail in the discretion of the judge. The court ruled that a judge should consider the nature and circumstances of the offense and weigh the defendant's risk of flight in light of the strength or weaknesses of the Commonwealth's case and the potential penalty of a sentence to life in prison. The court further noted that appropriate considerations for a judge would include the defendant's family ties, financial resources, length of residence in the community, character, mental condition, record of conviction, appearances at court proceedings, or any previous flight to avoid prosecution or failure to appear at any court proceeding. It is important to note that the purpose of bail is not to impose punishment. The court has conducted a careful review of the details of the case and the defendant's history. The court's reviewed the filings that have been made, as well as letters submitted by counsel for the defendant and the update that was received from her attending trauma surgeon. The factual allegations in this case are both horrific and tragic. The potential penalty faced by the defendant, if convicted, is severe. The defendant has no criminal history. She does not even have a driving record. There is no evidence of any history of any abusive behavior by the defendant. The defendant was raised in New England and has extensive ties to the local area. She has an extremely supportive family. She had worked for several years in a local hospital, and a number of co-workers have written letters in support of the defendant and her character. She's described in these letters as an exemplary worker, colleague, and friend. In the letter submitted by her attending trauma surgeon, she has extensive injuries that will require long-term inpatient rehabilitation. Weighing what the doctor has written and the facts from the defendant's current condition, the court finds that there is minimal risk of flight given the defendant's circumstances. The court is going to make the following order on bail. The defendant shall remain in her current hospital until medically cleared to be moved to a new facility. As a condition of bail, the defendant is ordered not to leave the hospital until discharged to a new facility. The defendant shall provide notice to probation 48 hours in advance of any transfer to a different facility. Based on the letter of the doctor, it would appear likely that she would be sent from the hospital setting to a 24/7 rehabilitation facility, like the Spalding Rehab. As a condition of bail, if sent to a 24/7 rehabilitation facility, she is ordered to remain in that facility, with the exception of if she needed to be transported to a different medical facility or a hospital for an additional MRI or something like that. The defendant shall continue to receive mental health treatment while hospitalized and sign releases for probation to monitor compliance with counseling. In the event that the defendant were to complete services at a 24/7 rehab and complete that care, the court would hold a further hearing as to whether or not the defendant were in need of further mental health treatment that would need to be done in an inpatient setting, or whether or not the defendant's mental health care could be provided in a residential setting. The court would direct court clinician, court doctor, to consult with the defendant's mental health providers to conduct this evaluation at the appropriate time in the future. If the defendant were in a position that she was going to be discharged to a residential setting, both sides would have the opportunity to be heard further. any discharge in a residential setting, the defendant would be subject to home confinement with appropriate electronic monitoring to monitor home detention. There would be exclusions that would be available if the defendant needed to attend medical or rehabilitation appointments, counseling sessions, or religious worship sessions. The court would have probation visit any proposed residential setting prior to the defendant being discharged to that type of a setting to ensure that such setting was appropriate and safe. The defendant is ordered to surrender her passport to probation. In the event that the defendant does not have a passport, she is prohibited from applying for a passport. The court is not going to set any monetary bail at this time.
And then some of the pretrial matters, we're going to go, I want to talk to counsel in regards to if the defendant
Okay, so she did not get bail. I'm like confused, and all that stuff that he said, I'm still confused. Did the girl get bail or not? I mean, I know she in the hospital because she can't go nowhere else, but did she get bail? I can't even, I mean, I don't know. How do you even tell that? Okay. So this is the next video. In regards to some hearings that I was able to find. I don't know, but that was kind of like that arraignment was pretty. I'm glad that I listened to that arraignment, because that kind of I don't know. It's like okay. Those are some very guilty looking allegations. I wonder if all of that information comes into our trial, because from right there, like, I'm like, she guilty, but you know, that's kind of like face value of the stuff. Let me see. Okay, so they just basically saying that she didn't have to go to like a jail. I don't know. And she can stay where she at. Okay, let's go on to the next one. I think I'm getting these all in the right order. We'll see. They only like an hour long. I think it's like maybe two more, maybe one more. Sorry guys, maybe one more, and then that's like it. And we've seen them all over here. Yeah, and so now he's remarried now. They said that in court today. His attorney spoke out because it was like some different opinions going on whether or not he was married or not, and that has been confirmed with today's yeah, that's been confirmed, baby. He married, he got a whole new family. He wish y'all would leave him and his new family alone, and I do mean alone. Leave us alone. Okay, let me update our thing in regards to this hearing happened 8 months ago. That way I can understand exactly what we're doing. I know our other little case that's coming out of Florida that's gonna be gearing up next week with the Microsoft murder. That's coming up next week. Next month. Next month. Sorry guys, not next week. Next month. We gotta they've been having a lot of hearings too that we probably gonna have to look at before we do it too. So this hearing is from November the 18th, 2025, guys. Just so y'all know. No, November 18th, 2025. That way, if people come in and they ask, we have it up here. Okay, let's see what this one is about.
The next matter we have before the court is Commonwealth versus Lindsay Clancy. Miss Clancy is present by way of Zoom. She is represented by attorney.
Matters, we're going to go, I want to talk to counsel regards to if the defendant.
Plymouth County House of Corrections, we have attorney Jessica Kenny present. Plymouth County House of Corrections, we have attorney Jessica Kenny present. Plymouth County House of Corrections, we have attorney Jessica Kenny present. Plymouth County House of Corrections, we have attorney Jessica Kenny present.
Records. And then I know that we had planned to discuss some of the legit. Yes, please.
Your Honor, the next matter we have before the court is Commonwealth versus Lindsay Clancy. Miss Clancy is present by way of Zoom. She is represented by attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague, and from the Plymouth County House of Corrections, we have attorney Jessica Kenny present.
All right, counsel, good morning, thank you for being here. I know that we have a couple of things we wanted to deal with, and so I thought what we could deal with first, I know there's a motion for change of venue, there's a motion to continue, and then there is a motion regarding some records, and then I know that we had planned to discuss some of the logistical issues that we're going to have in trying this case. So my thought would be to deal with those motions first, and then talk a little bit about the logistics, and that may require a sidebar conference involving the parties here. But why don't we go forward? I think probably the first one that we should address would be the motion to continue. All right, and so this is Ms. Clancy's motion, and so defense, I'll hear from you.
Thank you, Your Honor. Your Honor, I'm sure I don't have to tell you that this is obviously discovery-intensive case. We have electronic media, we have obviously grand jury, police reports, investigation, very, very complicated issues. We're also working our way through the mental health issues. As Your Honor is aware, we've already placed the government on notice under Blaisdell that there is an intent to present to a jury lack of criminal responsibility. We've got a number of expert witnesses that would be involved in the testimony from the defense. The government filed their request for independent evaluation on their part, and we have yet to do that. Some of the delay, if not all of the delay, would be on me. I'll admit that up front, Judge. I mean, I've certainly been, I've had 3 murder trials in the past, I don't know, 3 months, and along with a bunch of other cases, so I apologize for that. But I have been working my way through it with the DA's office. They've been very understanding, which I appreciate. We've just got an awful lot of stuff that we have to accomplish between between now and presently, the trial date is February. My concern is I have another matter in another county that's on for trial in December that's going to take about 2 weeks, and then if we were to move the case into early spring, I have a matter in federal court that's going to take about 3 weeks to try, and I'm concerned about losing the time to prepare adequately for that. So my suggestion, I think government may agree, would be if a July date is available, we'd appreciate that.
Commonwealth.
Your Honor, the Commonwealth assents to the motion for continuance for many of the reasons that defense counsel has stated. There has been a delay in getting the records to the Commonwealth's proposed experts. They've requested additional records, so they're not even at the point yet where they can then schedule the testing and evaluation of the defendant. That will take some time, and then, of course, the next step is getting the reports in, and then the exchange of reports, and then preparation for trial. As defense counsel has stated, this case involves a lot of digital evidence, DNA evidence, very complex investigation, and I also have trials scheduled as well as defense counsel does. So I think a continuance makes sense at this point.
I know that there had been some discussion about, I think in the motion it was mentioned June or May or so. That seems to be more, I mean, that's what I was thinking in regards to the timing and the calendar of it, maybe sometime in May. Do the parties see any problems? I guess first in the Commonwealth getting the evaluation, the reports done, because I know that's a little bit out of the Commonwealth's hands as far as the timing of it. And having done these cases, I know what's involved. But I thought that's the year we were talking. If it was sometime in, say, May, is that a problem first in regards to getting the evaluation and the reports? Because what I would not want to do is pick that date and then have everybody getting ready for that, and then through somebody else's schedule problems, we can't get that. So I'm kind of, that's why I'm throwing that out there.
Yes, so I think with everything that remains to be done, and also factoring in that we have a lot of holidays coming up, and people's schedules can be packed because of that as well, I think June makes more sense. The reason we had talked about July is because we were looking at the court calendar and noticed that Your Honor was scheduled to be back in Plymouth County in July. So we thought it made sense, since you were going to be here anyway, rather than having the court have to switch with someone. But that's more of a scheduling issue for the court than us. We were just trying to accommodate that.
Okay.
But the Commonwealth could be ready mid to late June, I would say.
All right. And the problem with mid to late June is it's almost July, and then we've got different schedule issues going on then. So the other question that I would have is that my understanding on this case is that there are a number of experts that are going to be testifying. And you get into July, what I don't want to do is have a date and we get ready for trial, and then somebody says, I'm going to Truro, or I'm going, to the Finger Lakes, or I'm on vacation. That's always the problem, and the two of you know it as well. That's a problem with a trial, especially in July. So I don't, is that something you're concerned with, or do you think that in reaching out, you could kind of nail down some specific times? Because I know that there's a whole slew of possible experts that may be testifying on any number of issues here. So it's hard enough to line them up. I guess that's the bottom line I'm saying there.
I think that's always a concern with a trial, any trial, especially a trial of this nature that's going to take the time it's going to take, and panelment will probably take a while in this case as well. So I'm not sure if we wanted to select a date today and then confirm it with our experts, and then come back in if there's an issue quickly. But
it's always a concern in the summer, trying to arrange around people's vacations.
Yeah. Attorney Reddington?
I don't take vacation, so it's fine by me.
I know that we can make you be here. The question I have, if there's especially out-of-state witnesses that I have problems getting my hands on and making sure they're here.
If we're able to put it over to that length of time, I think clearly we've got plenty of time to nail it down. My understanding is, and from my dealing with my people, is that there would not be any issues as to conflicts, and I'd make sure that that's nailed down, it's carved in stone.
And so if we put it sometime, maybe in mid-July, do you think that would?
Yeah, that's fine.
I mean, you certainly want to avoid the 4th. I mean, it just the realities of it, and not because of it's just the availability of not only experts but jurors. It's going to be difficult getting jurors to commit at that time.
July 13th, Monday, or even the 20th, whatever.
Come on, July 20th.
That's fine.
Thank you.
And Rule 36 would be waived, Your Honor?
Yes.
Yes, of course.
All right. So at the defendant's request, motion to continue the trial date to July 20th is allowed. Rule 36 is waived. Then from just kind of a next date, because that is putting it out far enough. It still seems like there's a lot of moving parts that are involved here. I mean, I think it would probably make sense to pick a date, maybe even into like January, for a status and scheduling, just to kind of see where we are in regards to records, where we are in regards to the evaluation and the reports. That'll also give everybody the opportunity to maybe double check with all the witnesses, so we don't have any surprises as we get a little bit closer towards the trial date, that we'll know for sure that we can reach that. So I'm going to be back here in January. And so because I thought we were going to be here in February. So we could just pick a date, maybe sometime towards the end of January, that would be convenient for everybody. Any
27, 28, 29.
Does that work, Colin?
Yes.
Let's say the 27th. All right, and that,
Want to do 2 o'clock?
yeah, that'd be 2 o'clock. So 1:27, 2 o'clock. Just status, scheduling, any other various issues, especially records, and I just want to know where we are in regards to the evaluation. All right.
Did Your Honor also want to set a final pretrial?
Yeah, well, that's.
On July 13th,
Yeah, that sounds good. Does that work? July 13th?
2 o'clock?
Okay.
All right. So that takes care of motion continue. The next motion that I have is the defendant's motion for change of venue. There it is. All right. Attorney Reddington, I'll hear you on that.
Thank you. Your Honor, first of all, change of venue, obviously, as the court is certainly well aware from your own defense practice as well as a judge, is a matter that's really vested in the sound discretion of the court. And as counsel in her opposition noted, that you are more than capable of inquiring of jurors in a sensitive way to thoroughly probe them to any biases or prejudices that may exist. We're all aware, I'm sure, that your associate, Judge Frenier, denied the motion to change the venue on another high-profile case, the Walsh matter in Dedham Superior Court a couple of days ago. Her findings were obviously very detailed, just as Your Honor would make findings. As I stand here now, I understand that it's an uphill battle to get a court to change venue. I know this. I mean, I represented Thomas Toolin. I'm well aware of the issues that are involved in a motion for a change of venue. I do not have any concern about the people or the citizens of the county of Plymouth and their ability to sit in judgment on this case and be objective and fair. My concern is the overwhelming nature of the publicity on a case such as this, which is readily understandable. My understanding of the law is that I have an obligation that I have to file a motion for a change of venue, provide the court with exhibits or documentation that would allow you to determine whether or not there's been a saturation of the county, if you will. I've requested that the matter be transferred to Suffolk Superior Court. I think that the city of Boston is in a situation where it would be more likely to obtain a jury that would be less exposed to the hysterical publicity that has been involved with this case. With that understanding, looking at the law, I understand that the court is in a position where, as many courts do, can deny the motion and defer the matter to the time of trial and see how it shakes out as far as individual voir dire with jurors. I still have to file the motion. I still feel in good faith that it's a matter that would be best sent to Suffolk County for trial, with the understanding that, as in the instructions from the Toolin case, from the Supreme Judicial Court, that in that case, obviously, I raised the issue. I had the motion before the judge. It was denied, and then ultimately it was flipped. As counsel points out, there was a number of other issues that were involved with the actual impanelment process in that case, but nevertheless, it's an issue that the court can consider. So I'm asking that you consider the voluminous exhibits that have been attached. I know that District Attorney in her opposition made note of the fact that I was kind of holding court down on the first floor there the day of I think it was the arraignment in this court. Anybody that knows me knows that I generally do not court, if you will, the media. I'm generally known not to give interviews. I quite frankly don't like to do interviews and things of that nature. I was confronted by a sea in a wall of reporters and cameras when I was trying to leave here with Dr. Zeisel after we did the arraignment. And this case obviously just grabbed, understandably, the emotions of the public. And we had heard, rightfully so, from the government as to the police and the investigation and the emotion involved with the police and the fire department. And we had the chief of police making statements that she's going to be okay. She's going to be walking and playing soccer within a week. She's not paralyzed. Everything's fine, which is all, quite frankly, not true. I tried to respond to the questions that were raised rather than just like Moses parting the Red Sea, walking through the wall of people, saying no comment. I said simply that this is a case that involves itself with medication, over-medication, postpartum psychosis, postpartum depression. All hot-button issues that certainly impacted on a woman who, by all accounts, neighbors, friends, co-workers, amazing individual and a loving mother, that all of a sudden would be involved with such a horrific act. And everybody wanted to know why. What was the understanding as to what happened? Without getting into the details of any investigation by the government or by the defense, I tried to respond to that. So I was not creating a media frenzy by any means. And that has carried through with the reporting. Your Honor knows that we're in a very strange time as far as electronic media, YouTube, podcasts, people that criticize the clothes you wear as an attorney, the way you walk around the courtroom, the questions that you make, the electronic surveillance, if you will, of the public It's amazing. So dealing with that and understanding the intense publicity that has surrounded this case, I think it is a legitimate motion. I would ask that you act favorably on it, understanding if you deny it, that it would be renewed at the time of trial in accordance with Tulin.
All right, thank you. Commonwealth.
Thank you, Your Honor. Commonwealth would ask that you deny the motion for change of venue, mainly because the defendant has not met her burden, based under the law. There are 5 characteristics or criteria that the courts look at that I went into depth in my memo, so I'll just highlight briefly. But the time that has lapsed in this case has been 3 years, which is similar to other cases that the SJC has upheld, as enough time has passed to not negate the impact of the event on the community, but to dull the impact somewhat. Also, the community size and makeup. This is a very different community and makeup than in the Tulin case. In the Tulin case, that defense cites, it wasn't overturned because of presumptive prejudice, because of presumably the jury pool would be prejudiced, but actual prejudice because it was such a small community of about 10,000 people who all, or mostly all, knew either the victim or her family, or interconnected with witnesses and the police. So it's a very different situation. In that case, as well as Leahy, both cite to Plymouth County as being a different type of county that's more urban, that's bigger in size, and the defendant will be afforded a diverse jury pool in this county. Also, the circumstances of the crime haven't set the community against this defendant. There have been no protests, no marches, no demonstrations that you can see in other cases that the SJC has determined that there needed to be a change of venue. We don't have any of that here. As to the voir dire, of course, Your Honor, will do an in-depth, thoughtful voir dire to protect the defendant's right to a fair and impartial trial. As far as the media being not being highly prejudicial, I think that's also true in this case. Most of the reporting, even the articles that defense is attached to his motion, are not against the defendant. They represent, or they describe each side's view of the case, but they don't give opinions as to which is correct, or go into hyper into details about the case or our positions. Defense did participate in some of that media. I understand that he said he went down after the arraignment and was confronted with this wall of media, and he felt the need to clarify some things. But he did give an interview to the New Yorker, and that article was published just about a year ago in October 2024, where he gave some thoughts on this case. And one of his experts, Dr. Phil Resnick, was also interviewed by the New Yorker and gave thoughts on this case. Whatever's out there in terms of their defense was put out there by the defense. I think we also have to consider the fact that the day and age we live in, it's not a day and age where there's local media and everything's condensed in one area. Local media, even the Patriot Ledger, the Enterprise, can be read by someone in Germany. It's everything is everywhere. And moving it to Suffolk, I don't think would help in any way, because many of the articles are from the Boston Globe, the Boston Herald. The media is Channel 5, all the local news stations, as well as national publications. So the entire Commonwealth has been exposed to all this media. It's nothing particular that only citizens in Plymouth County have been exposed to. So I think the fact that time has passed, the size of the community, the nature of the press at this point, and then the work Your Honor will do with counsel to ensure that we have a fair and impartial jury, I don't think it necessitates or rises to the level of needing a change of venue.
All right. Well, I've had an opportunity to read the defendant's motion along with the exhibits, the Commonwealth's opposition. At this point, I'm going to deny the motion to change venue. I will issue a written decision on this in the next day or two, but I had the opportunity to review all the pleadings and all the case law in regards to this, so that motion will be denied. Now, in regards to, there was a motion regarding records.
I think it was a letter from Dr.
Right, yeah, but it is a reference to the, we
we should probably address that over here inside first. right, so the next issue that we have to address really is, again, some of these just kind of the logistical issues in regards to the transportation of the defendant and other kind of related issues. Now, I've asked, and the sheriff's office is here represented by Attorney Kenny, and I was hoping, Attorney Kenny, that you could kind of tell us what would be available in regards to transportation of somebody like Ms. Clancy in her physical condition.
Yes, thank you, Your Honor. Jessica Canny on behalf of the Sheriff's Department. In anticipation of the HAPE that the department received, originally we had been ordered to bring her here on this date. I asked our medical department to reach out to the medical department at Tewksbury Hospital, as what often happens when there's a continuity of care issue. And I did bring with me our HSA, that's our Health Services Administrator, in case the court has any follow-up, but she did reach out to the medical team there, and she did learn that Ms. Clancy is confined to a wheelchair. However, she can self-transfer, and she can provide self-care in virtually all aspects of a day trip like this to the courthouse. And the only thing that Tewksbury was requesting was that we transport her via a wheelchair van, which the Sheriff's Department does have one of those vans available. She would be able to be put onto the van in her wheelchair. Understanding that there may be a very rare instance where she may need some basic medical assistance. We as well, I spoke with the HSA about having a nurse scheduled to go on the van as well. There's a drop seat in the back of that van. So there would be two deputies or corrections officers, obviously in the front of the van, and Ms. Clancy would go in the back of that van, and there could also be a nurse that could accompany her in a rare instance where she may need assistance. I won't discuss that here. If you'd like, I can go to sidebar further. But and so that was all that the medical staff at Tewksbury indicated that she required. They did report that she's pleasant, that she's quiet, that a wheelchair van was appropriate. She can independently move. She can independently transfer, and like I said, the vast majority of her medical needs that arise on a day-to-day basis, she can care for herself. So with that being said, that was our plan, was to send that van. Subsequently, I learned that Mr. Reddington filed a request under the ADA. Interestingly enough, he filed it to the trial court. He has not made that request to the Sheriff's Department yet. I did reach out and try to contact Mr. Reddington yesterday. I did not hear back. If the inmate were to, Ms. Clancy were to make that request to the Sheriff's Department, obviously we have many inmates in our care that require an accommodation under the ADA. We would engage in the interactive process as required under the law with Ms. Clancy through her attorney, Mr. Reddington. I did review the report of the psychologist that was provided. You know, what strikes me about it is it doesn't seem as a request for accommodation. It seems as a request for a change in custody status. I don't know how someone can be in custody and act as like a buffet, if you will. I want you to pay for my medical care. I want you to provide me protection. I want you to pay for my transportation, but I don't want to be searched. I don't want the handcuffs. And that's obviously very troubling from a correctional standpoint, because obviously if Ms. Clancy is remanded to our care, which she is at this point because she's held without bail, we have received a HAPE from the court to transport her. She becomes our responsibility, our liability. She's in our care and custody. And our officers are very good at what they do, and they weigh a lot of security factors. And the courts, even in conducting an ADA analysis, give a lot of deference to jails and houses of corrections and the security measures that they employ. I understand the doctor opines that she is not flight risk and she's not a risk of harm to others, and even taking all of that at face value, assuming that that's true, it really fails to address two major components that the Sheriff's Department is concerned about. And one would be a fear of harm to herself. There is a history here that obviously would trigger certain precautions from a security standpoint to make sure that Ms. Clancy did not try to harm herself. And one I think that often goes overlooked would be the concern about harm from others. This case has received worldwide attention, and while certainly there are many sympathizers with Ms. Clancy, there are certainly other people that very outwardly vilify her for the charges that she has been indicted on. And so there is always a concern with a high-profile inmate that someone may act out on those. It would be very unlawful, but obviously could certainly act out on those impulses. And that's one of the other things about having security in place. I know there's been some talk about letting her walk in the court or come in the courthouse from the front as opposed to the sally port. What the sally port allows is for her to have less public access. It's certainly not a punishment, but it's a safety concern, and especially in a high-profile case like this, having the availability of a courthouse with a sally port certainly makes that transfer easy on our deputies. I'm sure it makes it easier on your staff, security staff here as well, because it prevents a member of the public from having access to Ms. Clancy. This would also ensure that she does have armed corrections officers escorting her there in a secure van, as opposed to just arriving on her own. Now, again, the only way I think really she could arrive on her own is if the court changes her custody status. We're certainly happy to discuss any particulars that the court has concern concerns about, but as stated, based on our assessment from Tewksbury, we had planned to transport her with a nurse to corrections officers in a wheelchair accessible van so that she would be safe and secure.
All right, I just had one question in regards to the nurse that would be able to go in the seat there. Would that have to be a Department of Corrections nurse, or could that be an individual designated, as a private nurse, or how would that go?
So our plan was to have a nurse from the Plymouth County House of Correction, one of our staff medical officers, go. I don't think, in our experience, we didn't think Tewksbury Hospital would necessarily provide that, especially where their assessment to us was that she likely won't need that. So, sort of to make it run smoothly. And obviously, since the van will be coming from Plymouth House of Correction anyway, it would be easy to put an extra employee on that van. As far as it being a private nurse, I'd have to talk. I do have our AD, our Assistant Deputy Superintendent of Transportation, here as well. I would like to further explore what the security concerns may be for that. I'm sure it's doable. It may just also involve a path risk of that particular individual, but probably doable.
I'm not asking for a commitment in a sense.
No,
because this is really kind of just to get information. At some point, I'm going to have to issue a specific order, so this is very helpful.
Yes. So it's probably, again, I'd want to speak with them, but what our plan had been was to send one of our medical officers from the House of Correction just to get on the van before it went to Tewksbury to pick her up.
All right. Either counsel, any questions? Mr. Reddington?
Question?
Any further questions?
No, I don't have.
Okay. Attorney Sprague?
No, Your Honor.
All right. Attorney Kay, thank you very much.
Thank you.
All right. My thought would be to hear from both of you at this point, and then I'm going to have to kind of fashion an order in regards to that. So I'm not going to rule right from here in regards to how we're going to do this, but this has been very helpful. And then get some feedback from counsel. So Attorney Reddington, I'll hear you in regards to what your suggestions are. And again, keeping in mind, this is going to be months from now. And so the hope would be to kind of put something somewhat in place so that we can talk about it, and it can kind of, if things don't seem like they're going to work, or someone has a better idea, we can do with it. But I think it's something we need to address sooner rather than later. I don't know, Attorney Reddington?
Thank you. Yeah, I do have a better idea, and I think, Your Honor, that this is power play. You have here the attorney for the, congratulations on the appointment, chief counsel to the Plymouth County Sheriff's Office. Apparently, there's also another person that's here, I forget who she said, the Assistant Deputy of Security. We have medical officers. We have a lot of the administrative staff from Plymouth County Sheriff's Department is here. It's not about the Plymouth County Sheriff's Department. It's not about, well, she belongs to us. It's not about, well, we're going to have her transported in a van that we don't even know what it looks like. We don't even know what type of medical equipment or accessories there are in the van. We don't know whether, this is like at the time of the original arraignment, where they wanted her to be held in the Department of Correction or South Bay, and that if there's a medical issue, she can go to Lemuel Shattuck. And I refer to Lemuel Shattuck as the great hole of Lemuel Shattuck, because anybody that knows anything about the criminal justice system in this state knows that Lemuel Shattuck is not a place that you want to go for medical care. And unfortunately, too many people have to go to Lemuel Shattuck in custody for that. She's not in custody other than your order, which is understandable, to hold her without bail. She has not been convicted. She is still presumed innocent. She is still a citizen of this country. She is therefore an American. She has a clear and present, despite what others may think, disability that is debilitating. It is daily. It is 24/7. She lives with that as a paraplegic. Your Honor can well imagine the medical issues that are involved. She needs help with day-to-day personal issues. She needs help, regardless of the sheriffs thinking, no, we can throw some guy from the medical department, like a veterinarian, and throw him in the back of the van and make sure that the van doesn't have cockroaches running around in it. We can chain it to the floor, and then we can bring her into the courthouse. We can run it through the Sally Port, and we can keep her in the jump cell. My suggestion to the court, when I filed the motion requesting that there be an accommodation under the Americans with Disabilities Act, I don't care if I filed it with the wrong place. As far as I'm concerned, this is the right place, right here before you. As an American with a disability, she is entitled to the protection of the federal law, regardless of the Plymouth County Sheriff's Office position. She's entitled to have a least restrictive alternative to her custodial status prior to and during this trial. I've worked with these gentlemen for many, many years, and they're very, very capable, very, very competent, very, very compassionate in dealing with people and citizens that are in custody, presumed innocent. I have absolutely no problem whatsoever with their taking care, custody, and control of her while she's in the courthouse. My suggestion is that she be brought, as in the motion that I brought, looking for some help and looking for some least restrictive terms and conditions of what we're going to do logistically. And I know that this is a difficult issue for the court. I know that you're a compassionate person. I know you've got great experience in your career, and I know that you're concerned for the government's concern as well as the defendant's concern. I know this. But my suggestion, Judge, is that if the sheriffs have to be involved, then, which I don't think they do, honestly, because, and I think for the courts, you're probably more than aware, under Chapter 123, Section 21, it's a statute that talks about transporting somebody who's under a commitment. Transporting, and she is definitely under a commitment per Chapter 123. Your Honor knows that she's under a commitment that was entered back in May. It's good for a year. And the authority for the transportation, I hate to break this to the Sheriff's Department. The authority is not in the Sheriff's Department where they are the almighty end and determine what's going to happen to Lindsay Clancy as far as being in a van and being transported and being chained and being held in custody and all the rest of it. It's up to the head of the Department of Mental Health or Tewksbury. She can be transported from Tewksbury with a nurse, with compassionate people that she knows and that she deals with, placed in an ambulance that has the appropriate medical care and treatment, brought to the courthouse, run her through the Sally Port, I don't care. I'm not saying I want to have her brought in the front door, have her brought in the Sally Port, turned over to the care, custody, and control of the court officers, and then placed somewhere in this building, as Your Honor had pointed out, that would be safe and comfortable during the course of this trial. That under 123, Section 21, general custodial duties of the sheriffs is Chapter 37, Section 11. 37, Section 11 is superseded by the mental health statute. It prohibits the use of correctional or police vehicles without written approval of the Commissioner of Mental Health or the facility superintendent. Now, I understand that they have, I guess they call them chase cars. So if they want to have, a piece of the action, as it were, they can throw a couple of guards in a van as a chase car and follow the ambulance to the courthouse. If the government is concerned, not the government, if the sheriff's department is concerned about her being attacked and assaulted by people, then let them have a chase car. In other words, they can send a van, go up to the hospital, put her in the ambulance with a nurse, bring her down to the courthouse and have their chase vehicle with 2 or 3, however many they need, armed guards to guard the woman in the wheelchair to make sure that she doesn't attack anyone or that nobody attacks her. So the bottom line is that the least restrictive terms and conditions of transport and custody during this trial, Judge, I suggest would be to allow an ambulance, a real ambulance, not a medical van with jump seats, but a real ambulance, transport her to this courthouse with a nurse, placed in the custody of the court officers, brought to a room or wherever contiguous with this courtroom so we can try the case. Sheriff's Department has been superseded by the statute. They do not, I would argue, have the custodial authority to transport her according to what they see fit. So I would ask that the court would, and I understand you don't have to enter an order today. This is something that can be explored, something that can be considered. My concern is I have a person who's presumed innocent, who is a paraplegic, who, as you heard from counsel's representation, is by reputation and observation docile, quiet, timid. She's not assaultive. She's not a danger. And quite frankly, I disagree. I don't think that the public would want to hurt her in any sense. So it strikes me that under the statute 12321, I think the court has the authority to allow Tewksbury to bring her here, have her in the van, have her with a nurse, let them chase car behind her if they want, bring her here, and then put her in a contiguous room, and then Jen and I can try the case.
To be clear, Your Honor, if you are ordering Tewksbury to transport her, the Sheriff's Department is not involved at all. The only reason I'm here is because the court sent a HABE ordering us to transport her from Tewksbury here, and so we're not sort of resent the implication that we're interjecting ourselves into this impermissibly. I was requested to be here, but also...
You know what? Here's the thing. I'm looking for information. I'm not looking for a fight at this point. There's plenty of time later for this fight. So I appreciate the sheriff's position. I appreciate the defendant's position. I think I've got the sheriff's suggestion as to how to go forward. I'm hearing the defendants. I'm going to take them both into consideration, and now I'm going to hear from the Commonwealth.
But just to be clear, if you do order DNA to transfer her, the Sheriff's Department does not need to be involved.
Okay.
I mean, that's the only reason we're here is because of the order to transport her from this court. We're not looking to involve ourselves in some other department's transportation.
It just so it's clear, the court had asked the Sheriff's Department to be part of this today, so I could get the input into what the sheriff's alternatives would be. So I'm the one who kind of pulled them into this. Attorney Sprague.
Thank you, Your Honor. The defendant's not only held under a commitment under 123. She's held without bail on 3 counts of murder as well as other charges. While she is a paraplegic, the Sheriff's Department has clearly articulated that they have the means to transport her to court safely, to send a clean and well-staffed wheelchair van to Tewksbury to pick her up, to have a nurse present, to bring her back and bring her into court, just the same way any other person who's held without bail on a murder case is brought into court and should be brought into court. Notwithstanding her issues in terms of transportation and needing a wheelchair, she should be treated the same as any other defendant and not be given special treatment. She should be given accommodations due to her condition, but not special treatment. And has those accommodations. You heard from Attorney Kenny that they spoke to the medical staff at Tewksbury. She's able to move herself in her wheelchair. She's able to transfer herself in and out of her wheelchair. She may need some slight assistance during certain personal care situations, but other than that, she's self-sufficient. So there really should be no other special treatment other than getting her here safely, and then making sure that she has adequate access to personal care situations. But I think that any other accommodations requested by defense are unnecessary and would just be special treatment for no reason.
I'm going to, first off, I want to thank everybody for giving me the information, because this is not something that I had, really right at the tip of my finger, so it's very helpful. I'm not going to make a decision right now as to how the defendant is brought into court. I'm going to draft an order, and then I will probably send it to all the parties, and then it may be something that we want to have a further hearing on, a further date, and then it may be something that we may want to even before the trial date, see how that order works. In other words, have Ms. Clancy come in for one of the hearings or so, just so that if there's something that I haven't thought of, we can kind of see that, so that when we do get to the trial date, it's as smooth as we can make it. So that's what I'm inclined to do here, is just come up with a draft order for transportation, and then we can kind of address it. We know now that we've got a little bit more time than we thought, because of my moving the case into July. So that's what I'm going to do in that. Anything else we need to address today? Attorney Reddington?
No, thank you.
Attorney Sprague?
No, Your Honor.
All right. So at this point, we've got that next date in January. I'll get the draft order in regards to.
Okay, so that was that hearing. I hope this next one that I pull up, the sound is better for us, because if it's not, then I'm probably be out on them and the sound. So let me see. Yeah, this one is probably about 30 minutes. You say you retired now, you do whatever you want to do. Oh, wow. SD 50 years? Gee whiz. Say it ain't so. Just say it ain't so. I know. Look, Victor, I'm not shouting. You just got your volume all the way up because the sound was so terrible. But here we go, guys. This is the next hearing. I want to hear her say something.
The best way to deal with this, number one, I want to kind of find out how the evaluation was scheduled a week or two ago. Kind of see how that went. And I know there were some discovery motions that were filed by the defendant. I know there were some Rule 17 motions that were filed by the Commonwealth. And then maybe if we had a couple minutes, we could talk about a little bit about the procedures. I know there was some suggested voir dire questions. I know it's early, but it's never too early to start talking about jury selection. So I guess first off, any issues arising out of the Commonwealth's evaluation of Ms. Clancy a couple of weeks ago?
No, Your Honor, two of our doctors evaluated Ms. Clancy over a 3-day period. The third doctor that we have retained is going to do a Zoom interview with Ms. Clancy, and we made sure that his doing that separate interview wouldn't impact the timing of his report or delay the trial in any way, and he assured us it wouldn't. So we're getting some dates from him to coordinate with defense counsel to get that done. But I think we're on track in terms of the evaluations and when we'll have reports.
All right. Mr. Reddick, any issues that you saw come up during those evaluations?
No, they went very smoothly. Thank you.
All right. So that then kind of begs the next question in regards to those reports. Do you have a time estimate that the three of you have talked about?
I believe what we had talked about in the court before was end of May, beginning of June.
Okay. All right. So that first issue seems to be resolved or on its way to being resolved regarding the evaluations. Now about the discovery motions. The parties ready to argue those?
Yes.
All right. And so I've got, I think there were two. I don't know, were there any more than?
I think there were two.
All right, because I was coming from out of county, so they were clerk's office was good enough to forward those two. I just wanted to make sure I had those. So I have the first one we can take up maybe is, it's called the motion for discovery regarding communications. Mr. Rankin, I'll hear you and then I'll hear Commonwealth.
Your Honor, I'm cognizant of the case that actually came out of this county. I believe it's Commonwealth versus Caldwell. It's a great case where the gentleman was in jail for almost a decade, and there had been a number of post-conviction hearings before various judges denied as far as the defendant's request. But then ultimately, on a Rule 30, it became apparent that there had been exculpatory statements made that were known to the prosecution. I'm not suggesting for 1 minute that I have any information that either one of these prosecutors, who I know very well and I would never suspect would not do anything other than provide me with what I should have. But in the Caldwell case, the Supreme Judicial Court noted that defense counsel has an obligation, and this is before they changed Rule 14 and updated Rule 14, but I still don't think that the updated Rule 14 trumps, if you will, the Caldwell dicta, where the court noted that the defense attorney did not make a specific request for any and all communication between the prosecution team, if you will, including the prosecutor, the DA, police that we all consider to be part of the team, but also victim witness advocates, and in that case I think it was a victim witness advocate that had a memorandum where there was an exculpatory statement made by, is my memory, the alleged victim. So the SJC did allow that motion and did grant the person a new trial based on that. So based on the Caldwell case, I'm just asking that the court enter an order for us to get access to all communications from any of the prosecution team with witnesses, including the physicians that have been doing the government's evaluation of Ms. Clancy. And that would include emails, texts, obviously written materials, notes, memoranda, coterminous with discussions that might refresh someone's recollection. I am cognizant, I filed this motion on a murder case up in Newburyport a number of years back, interestingly enough, where the issue of ballistics was in play, and it ultimately resulted in the production of an email from the prosecutor to the ballistician saying, please, 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 I have to have you hook up this bullet or I have no case. So needless to say, that resulted in a defendant able to raise that issue with the court. So I'm asking that the court would enter that order. And finally, I'm asking that if it relates to text messages, and I hate to even mention the case, but the Karen Reed case, where that detective, his personal cell phone was utilized, not his business cell phone. So I would ask that the court would enter an order that personal or business related cell phones, computers, tablets would cover under that order.
All right. Come on.
Your Honor, I would object to this motion. We are well aware of our obligations to turn over any exculpatory information, and if there was any in this case, I would certainly turn it over, but I haven't found any. So I will honor that obligation going forward. Despite the changes to Rule 14, work product is still a thing, and all of what defense counsel has mentioned is work product, unless or until there is some exculpatory information or a statement by a witness that we would, of course, turn over. As far as personal phones, I don't use my personal phone for work purposes, so I would object to anyone having access to my personal phone. But in general, I would just object to this. There's no foundation, no basis, no information that any exculpatory information has been withheld, unlike cases post-conviction where there is evidence that is brought forth and then motions are allowed for this type of discovery. But that is not the case here, and it will not be the case here because we will honor our obligations under Rule 14 and our ethical obligations.
So, Mr. Ray, you're looking for evidence kind of beyond Rule 14, it's kind of a Rule 14 plus?
Yes. Communications, for example, if there would be text messaging between, and I use the example of a particular victim witness advocate and a doctor, or the doctor communicates with someone from the DA staff regarding an issue that arose during the course of the alleged independent evaluation, anything like that I'm looking for. And that would be, as I said, based on Mr. Proctor, former Detective Proctor, I think personal devices would have to be included. And I'm not trying to be invasive to anybody's privacy by any means, but that is an issue that was brought to the fore significantly during that trial, so I do include that request.
And I think that became an issue when evidence of such matter became known, and then that opened the door to that type of discovery, which is not the situation here.
All right. I'm going to take that under advisement. I've got to go back, review Rule 14, as part of the prosecution team. And Rule 14, I think, specifically mentions victim witness advocates now. But I also then have to review the work product kind of statement. I'm going to take a look at Caldwell. So I'm going to take that under advisement.
Okay.
Let's see. All right, the next motion is for discovery regarding government's medical witnesses.
Could I apologize. You're on the site for Caldwell. It's Commonwealth versus Clifton Caldwell. It's 487 Mass 370.
That's helpful. Thank you. All right. So I'll take a look at that, especially in light of Caldwell. And then regarding pleading number 74, which is the motion for discovery regarding government's medical witnesses. So, Mr. Ray, can I lay on that?
Your Honor, in that motion, I'm asking that the court would entertain a request that we be advised of the cases that the government's chosen doctors have been involved in a criminal case, certainly not during their entire practice, when they are engaged as an expert either for the government or the defense, requesting information as to the percentage, if you will, of their practice how much percentage of their practice would be for the prosecution, how much for the defense, and then obviously the name of the cases or docket number and references in the event there was testimony, not so much a plea. I'm not looking for, the government to provide me with their reports on these cases. I'm looking for the name of the case, the court location, the docket number, and whether or not they testified for the government or the defense. I'm also looking for, I think there was some other request. I don't have the motion in front of me.
Yeah, there was the fourth paragraph was directing the physician to produce and make available to the defense notes, records, memoranda.
Yes.
So I think that was in addition to
refresh my memory, Your Honor. So obviously, and I don't know, maybe there are not because of the fact in this case, as you know, we filed a motion to have the interviews recorded, which they were recorded. So I don't know if that obviated the necessity of anybody taking notes. A lot of times the doctors will say that interferes with the relationship between the patient or the defendant and the doctor who's doing the evaluation. So those are the requests that I have in that regard.
So
I specifically did not ask for the amount of money that they have made, and the reason is that I personally feel in the cases I've tried, I can literally tell you, never have I ever asked a doctor, expert, anyone, how much money did you make on this case? And I always say, in the event the government asks the question, I always say, look, everybody's getting paid to be here. I'm getting paid, the judge is getting paid, jurors, not much, but they're getting paid. So it doesn't really matter what the funds are that they receive. I don't really care how much money they made. I don't think that's going to color someone's testimony at all.
I guess what I'm interested to hear the argument because it's above and beyond the CV that's supposed to be or by rule has been I imagine it's been turned over. It's going to be turned over. But then to ask them to go into their records and go back and dig through all that.
Well, it's not so much a matter of digging through all that as much as like when you get the CV and the CV says the following are cases that I testified and they name the cases, but you don't have a docket or you don't have a specific. I can't go hunting through the internet to find what case they're talking about. So I look for a docket number or location of whatever court it may be, Pinellas County, California, or something like that, or a docket number. And then I can try to see if there would be any records or documents indicating that what their testimony was. But they don't give you that generally on a CV.
Rule 14 only requires the curriculum vitae as well as any publications that they've authored. We've turned over the CVs for the 2 doctors who have already done the analysis, and we'll be turning over the 3rd doctor's information tomorrow, and those contain the publications they've authored. This is all above and beyond what's required by the rule. There's nothing in the rule or in the case law that requires us to go on a search for this information. If defense wants to use it in their cross-examination, then they have to go and find it. We're not required to help them with their cross-examination. Unless there's something exculpatory and we find that, we will of course turn it over. I don't think Rule 14 requires me to do math either, so asking for the overall percentages of cases. And if anything is allowed, I'd ask for the same reciprocal discovery from defense counsel on his witnesses. But in the Commonwealth's position, this is all well beyond the scope of Rule 14.
So I can assure you that I know every article that these guys have written, and I've already gone all the way back to the high school. I really don't need the government to help me on cross-examination, but I don't think it's an unreasonable request to say that when they put on their resume or their CV what cases that they've been involved in, to know whether they're testifying for the government or the defense and some docket number. It's not requiring a lot of work to find a docket number or a court that it's in.
Defense counsel can do that same work.
I know. It's kind of hard for me to make this determination without seeing the CVs. Do you know what I mean? It may be, if I see them, it may be not a big ask to fill in these gaps, or it may be a huge thing to ask. I mean, if somebody's been an expert for 25 years and there's nothing on the CV about the specific cases, that's a big ask for somebody to go back through 25 years of your career and reconstruct what cases there were, that. Now, so that's just one comment I had when I was reading through that. The other thing is, I guess, I'd be interested to hear from both parties. Everybody, and I always ask that question, right? What percentage of the time that you've testified were you on behalf of the government or the defense? That's very common. I mean, I asked that question many times. And is it, I imagine, is it a big ask to kind of ask that question in advance from both sides, that everybody would know? I don't know, if you feel it is a bridge too far in a sense, let me know. But I'm just thinking, we've all heard that question, and if everybody knows what the answer is going to be now, is there a problem? Because then if somebody says it's 10%, well then the other side may want to do their own chasing after it, or not. They may be satisfied with that. I don't know.
I think it's beyond the scope of Rule 14, and I think it is a significant ask because we then have to go to the experts and ask them to review every case they've ever worked on and determine which side they were on, and then do the calculations to determine the percentage. And And really, it's not the quantity that's important, it's the quality of the work, and I think that can be examined in the cross-examination without knowing an exact percentage.
But don't you think you're both going to, I shouldn't say this, it would not be a surprise to me if that question was asked by both sides of anybody who testified here.
Well, I think there's two separate issues here. I mean, there are plenty of questions that might be asked of a witness, but it doesn't mean the Commonwealth has an obligation under Rule 14 to seek out that information and provide it.
I was just asking, I just kind of wanted to know what the Commonwealth's position was in regards to that. All right. What I'm going to do is, I'm going to take no action on this at this point, because what I want to do is maybe see the CVs. So I would then know what information both sides, because if I'm going to do one, it certainly would be reciprocal in regards to these requests. But I'm not saying I would. I just kind of need a little bit more information as to what the CVs have presented.
So I'll get the CVs from my side and present them to Donna, and she can
And I can do the same.
All right, and I'll take a look at them, then I'll make a decision on this regarding that. All right? All right, so I'll take that matter under advisement as well. Now, the next series of issues, I think, is in regards to the Rule 17s.
Yes, and I believe Defense Counsel is not objecting to those.
All right, so it's a request for Mass General records. And then there was one, I just kind of wanted to make sure I had it.
Right, there's one for employment records from Mass General, there's one for educational records from Mass General Hospital Institute of Health Professionals, and then there's one for educational records from Quinnipiac University, and accompanying that should be a certificate for out-of-state securing of those records.
So the MGH Institute is an educational, just kind of continuing education in the sense if you're working at Mass General, something like that?
Yes, they offer a bachelor's and master's program in nursing.
All right, so I'm going to allow those.
Yeah, I have no objection to that. I know they already obtained a number of documents and records from her employment where they were rating, peer review ratings and things, and she always aces everything, so I have no objection on that.
Do we need a return date in regards to those records?
Yes, and specifically for the out-of-state records, because there are spaces on those documents for a return date. We could do a 60-day date.
So we've got a June date anyway, don't we?
Right.
Already?
Yes. We have June 18th.
Yeah, June 18th, Thursday.
You want to put that at the same date?
That would be great, thank you.
That way, if there's issues, we might as well deal with them. If they're not, then we know we can just kind of check that box. All right. So we'll allow those with a return date of June 18th. Okay? All right.
Thank you.
Next issue, there was a request for release of the juror list. We had early. I allowed that, so I figured it'd come in here. So the parties have those?
Yes.
Thank you.
Thank you.
Then, just maybe a little discussion regarding the appealment procedure. I know that there was filed a suggested questionnaire along with a number of questions. We're not going to go through them. I mean, I think it's early, but it's like I said before, it's never too early to
It's
start.
never too early, and I just figured that, so council has it, you have it.
Yeah.
You can add, delete, deny, allow. whatever.
No, I think that's what I'm saying. I think that's helpful. In the Commonwealth, the same thing as we go through it. But generally, try case with everybody here. So generally what we do is I'd ask general questions. A lot of the questions are here. I'll ask generally, and then we'll just get an individual sidebar kind of as we go through it. And then, as we've done before, I'd ask you to exercise your challenge at that point rather than the old days, fill the box. And then, and so there's some questions in regards to the procedures, so that's generally the way we do it. If we do a questionnaire, my hope would be to keep it to one page. And I just think that it's easier for the jurors as well. But we'd still have individual voir dire no matter what.
So can I just question, when we do the individual voir dire, what's your practice? I forget, I've had many cases with you, but do you have the jury in the witness box and counsel stays at the table, or do you go up to the sidebar literally?
I generally go over to the sidebar.
So my request, if you would consider it, is that we use the witness box with the juror for a couple of reasons. I know there are many judges that do that, and not to mention the fact that it's a lot easier on the legs than standing there for hours on end at the sidebar. But my client, as you know, is in a wheelchair, so it would be kind of difficult where I always ask that the client be with me at the sidebar when we have that questioning of the jurors. So I just ask in this case that you would consider doing it through the witness box, just because it's going to be difficult.
Right, and I was thinking of that. One of the other possibilities is to use the what's it called, the whisper, like the headset.
If that's your order, that's your order. But
no, I haven't really done it. I'm trying to bounce off the different ideas. That's one thought. One of the reasons why I'm not necessarily a big fan of the witness box in a case like this, there's a lot of really personal questions that are going to be asked. In not just this case, in a lot of cases. And that's why I generally would do that.
Yeah, but there would be nobody else, I mean, as far as...
We can't close the courtroom.
So...
Right? I mean, you look at is, Commonwealth versus Cohen, which Cohen won, as I'm familiar with. But that's one thought. We can talk about, this is probably a better specific topic when we come back in June. But I just kind of wanted to get that out there, have people thinking about it. How are we going to do this? I'm not wed to that. I mean, this is a unique, each case has its unique characteristics, and this may have that scenario where we have to do it in the juror box. I just haven't really kind of finalized.
I just know that I've had many cases in various counties where judges will do the individual voir dire from the juror box. It works out well. I've never had any issues that I can recall in those cases. I know the court's got to balance the concerns, but I've done that whisper thing in federal court and state court. I don't like the whisper thing.
I never use it. I'm almost because I don't like it either. But sometimes it's, as bad as it may be, it's better than the alternative, as they say.
Well, not from my client's point of view, my point of view. I understand you're balancing other people's interests.
No, I understand. Commonwealth, any thoughts?
I prefer to do it at sidebar. I agree with the court about the personal questions. I think we're more likely to have jurors who are comfortable and honest answering at sidebar. We also send them out of the room to do our challenges, so defense could use that opportunity to speak to the defendant. But I would defer to the court on it.
All right. I'm going to think about that. And then maybe we come back here in June, have a better kind of concrete answer. I'll have to kind of decide how we do it. But I kind of wanted to just gauge everybody's thoughts and interests and position. So,
well, the other alternative is we could ask the court officer to construct a platform that we can put next to the bench, I suppose.
That's another possibility. So we'll keep all possibilities. But I mean, generally, we're either doing sidebar there, maybe with the whisper, but we'll weigh those out. All right. And then fine. So we've got the June 18th date, and then do we need one more date in May, do you think, to just kind of make sure everything's on track?
That makes sense.
I don't know. I mean, it sounds like things are going, I don't see any big bumps in the road here, but that's sometimes
my only
when
concern
we
is
get...
it's going to be difficult. I have 2 back-to-back federal trials in May, and this is probably going to wipe out most of the month of May. So I'll just let you know that up front, but we can go through some dates if you want.
current status, but that's kind of what it would be, to see if there's any issues that anybody sees that we need to address earlier rather than later when we come in. Well, May 21st is a Thursday. Good morning.
It's fine. Yes.
And if that becomes a problem from either side, just let us know. We can kind of, at least, and that's really just to check in regards to discovery, witnesses, and any other issues that we may have. Well, Leslie, could I see counsel at sidebar just briefly? All right, and then Commonwealth, anything for?
So for the record, this matter is continued.
I don't believe so, no.
All right, Mr. Rankin, anything further? No, thank you. All right, so this case will be over until, what was it, May 21st.
So for the record, this matter is continued to May 21st, 2026 at 2 p.m. for status, and we will have Ms. Clancy in by Zoom.
Yes.
Thank you.
Yeah.
So this matter is continued to then. And I think that brings us to the last one. So let me get that up. Didn't that mean we all caught up with all the hearings? I think. At least all the hearings that I was able to find. And I'm fine with that. Where is it at? Oh, I think it's this one right here. I think. Hold on. Alright, is this the one we just seen? No, I think this is the one we just seen. Wait a minute. Let me see. I think it was like a month ago. Let me see if I can find the thing. Oh, wait a minute. This is it. It's just real short. Let me get the date. So this is the one in May. I don't know. Hopefully the sound is gonna be okay on here. I don't know, because we'll see. If it's bad, then I ain't gonna be bothered with it. But it's because of the way where we watching it at. But let's see.
Good morning, Your Honor. May I proceed?
Yes, please.
Good morning, everyone. Today is Thursday, May 28th, 2026. This is the fourth criminal session at Plymouth Superior Court before the Honorable Justice William Sullivan. Your Honor, the matter before the court is docket number 2383CR00198, Commonwealth versus Lindsay Clancy. Ms. Clancy is present by way of Zoom. Counsel is present in the courtroom, Your Honor. Counsel, if you could please state your name for the record. We can start with the Commonwealth.
Good morning, Jennifer Sprague for the Commonwealth.
Tree Sprague, good morning.
Shannon Buckingham, also for the Commonwealth.
Tree Buckingham, good morning.
Morning, Judge Kevin Reddington on behalf of Ms. Clancy, who obviously is with us in Zoom.
Hi, Mr. Reddington, good morning, and Ms. Clancy, good morning. All right, so this is really more of just a status type conference. I just kind of wanted to see where we are in regards to discovery issues, and then also discuss kind of what we're going to do. The next date, which will be the final trial conference, is June 18th. I
right, so I just kind of I had that different date in my head, but I just wanted to confirm that. All right, so I guess first off, where are we in regards to the discovery? I understand that the examiner's report was filed. So, Commonwealth?
Yes, one out of the 3 examiners' reports were filed. Dr. Mack is working on his report, should have it to us sometime next week. Dr. Sathoff is interviewing the defendant tomorrow, and then again should have his report either next week or the week after. And then I think discovery will be complete on the Commonwealth's part. At that point, we turned over a last little bit of discovery regarding toxicology from the autopsies of the children this week. That was the only thing from the lab outstanding. So that's all set. The records from Mass General Hospital and Quinnipiac have come in. We just asked that the court order that we can inspect and copy them, both parties.
Counsel, any objection to that?
No.
All right, so both parties may be allowed to inspect and copy those records.
Thank you. I also have I provided defense counsel a copy of our effective witness list, so the court has an idea of how many people could potentially testify. I addressed one thing with defense counsel this morning. You'll note that there are 168 witnesses. A lot of that has to do with the Commonwealth versus Gordon case and the lab requiring that we call a lot of foundational witnesses, but we've been talking to defense counsel about that. And one thing that we wanted to put on the record this morning regarding NMS labs, that's a private lab that tested some of the defendant's blood. In order to get those results in under Gordon, we would have had to call, I think, approximately 12 witnesses and fly them in from out of state. Defense counsel, I believe, is not, well, I'll let you speak for yourself.
Thank you. Your Honor, I understand the Gordon case, obviously. I could put the government's feet to the fire, so to speak, and have them bring in literally every single witness that had anything to do with the care, custody, control, testing of the blood. I do not do that as a matter of course unless it's relevant material to my defense, which it is not in this case. So I told the DA that I would not be requiring them to bring 12 people in just to say that someone had the blood sample, chain of custody, somebody put it under a microscope, and they're going to have, I think, one witness that would probably testify to what the findings were. So we'll be agreeable on that.
All right.
And the others have been summoned, so if anything changes, we would make arrangements to bring them in.
I have, just so Your Honor knows, probably around 50 witnesses, but most of them are civilian witnesses. We've been very, very cooperative on both sides as far as exchanging reports and documents and evidence and things of that nature. And there seems to be an overlap on the number of the witnesses on the civilian side that's in the government's list is in my list, so it won't be that bad. It's not going to be that good, but it's not going to be that bad.
All right. How about from the defendant's standpoint in regards to discovery? Where do we stand in regards to that?
I will say that I have found the DA's office to be extremely responsive. I made a phone call about a month ago and requested opportunity to look at physical evidence. They had it all set up for me to go in. They were very accommodating, and Jen Sprague sends me an email or two once or twice a week with more discovery. So I'm good with the discovery.
All right. Commonwealth? I'm
sorry, I would just ask, and now that discovery is complete on the Commonwealth side, other than the 2 doctors' reports, I would just ask for reciprocal discovery in terms of any reports of investigators regarding the potential witnesses.
I don't have any. I never do.
Okay. All right. All right. So it seems to me the thing we're really kind of waiting on right now would be those final 2 examiner's reports. And then I guess the question I'd have, I probably know the answer, but is there going to be any objection to both parties with the exchange of each other's reports?
No, we've already started that.
Okay, that's what I figured. But I just, under the rule, I just wanted to make sure that's kind of where we were. So is there anything we need to address today that the parties think we should kind of deal with?
There were a couple of things that I just wanted to bring to the court's attention. One, Jessica Kenny from the Sheriff's Department had reached out about the June 18th date and whether the defendant would be here in person. It was my understanding that after today, she would be appearing in person for all dates.
Could I respectfully interrupt? I apologize.
Absolutely.
I have been ordered to start a trial in federal court that Monday, whatever that day is, the 15th, I think. Joseph Keresy is the case. It was advanced. So I just want to let you know, I'll ask the judge if, are we on at 2 o'clock?
10 a.m.
For 11.
Yeah. Can we put it on tentatively for 2? Because she might let me leave at, like 1, and then I can come down here for 2. I'm pretty sure it's carved in stone. It's definitely going. I'm starting one Monday in there too, and it's just going to go back to back. So I just wanted to raise that issue right now rather than wait until the day before,
Why don't we go back and address that? Because I think that's the discussion on that may best be done at sidebar, because it's going to talk about some medical issues and things like that. So put that one on hold. What else? Any other issues?
So what Attorney Kenny was asking for was that if the HABE is sent to Tewksbury, that a copy also be sent to her, because the Sheriff's Department is providing transportation.
Right. Yeah. We can do that. So any HABEs that go out to Tewksbury, a copy will be also made to the Sheriff's Department, because we talked about, they'll be providing transportation in their van from Tewksbury to the court, and then from the court back to Tewksbury.
Right, which has been very, very acceptable, and they've been very good, very great on their transportation.
All right. So, Commonwealth, what else?
So motions in limine are due next week on the 4th. We will be filing a motion for review. We have been in touch with the homeowner, the current homeowner. He does plan on objecting, and we'll have counsel here. So I just wanted to give the court notice that there will be a hearing on that.
On the 18th?
On the 18th.
Oh, we'll have a hearing on that, for sure. All right. So we'll
I'm not jumping in on that one.
Yeah, that'll be one of the hearings one of the issues we'll talk about on the 18th.
And I'll provide a copy of our motion to the homeowner's attorney.
Okay. All right. Commonwealth, anything else that you see?
No, Your Honor.
All right. Mr. Reddington?
I don't think so. I mean, the 18th obviously will address the issues that you said about any medical issues and things of that nature. No, I can't think of much of anything. The only concern I have is the motion in limines that are due next week. I don't know, honestly, if I'll be able to get them done by next week because I am starting that trial in federal court. But on the other hand, I can't really think of many defense motions in limine, so I'm not too concerned about that. So I know that the court would give me some latitude on that.
Well, why don't we do this? File what you have by, what's it, the 4th, due on the 4th? By the 4th. Commonwealth, file yours, what you have done by the 4th. Part of the reason I think that we had that final trial conference, about a month really before we actually start the trial, was because of things like this. So that we can, address whatever motions and eliminate the best we can at that point. So, just make your best effort. Counsel's experience, all three counsels very experienced, so I think you'll be able to kind of get what you can done by then. And if not, you need a little bit more time. The 18th is not going to be a problem because we're a month still out from trial.
And we also have a secondary final
Right.
pretrial date the week before trial.
Right. So I think I'm not that concerned about, but the sooner you can get them to me, the better, and the sooner to get it to each other, obviously. But my hope would be to address as many of them as we can on the 18th, so everybody has a good idea of what's in, what's not in. If we have to address later ones on the final date, which is the 13th, we can do that. All right. Anything else?
What about jury issues?
I thought we could discuss that on the 18th. I think that's, procedures.
Yes.
questions, questionnaire,
Right.
how we're going to do that. Even just straight procedures of, where it's going to be done, or, what sidebar, things like that, how we're going to do that. I think that's probably something we can deal with.
The sidebar issue is resolved. They told me that it rises up and down, so I think we're good on that.
Yeah. And so just kind of logistical questions about how we're going to do it, but mainly about questions. So if anybody has suggested questions, I know some have been filed already. I'll try and have kind of a working model when we come in on the 18th, and we can kind of talk about that.
Yeah, I think I filed my proposed questions in a questionnaire if you were inclined to do that. Yep.
Right.
Okay.
Yeah.
And the Commonwealth will file theirs by the 4th?
That's fine. All right. Other than the question about June 18th, anything else?
No, Your Honor.
All right.
No, thank you.
All right. So could I see a sidebar over here? Maybe if we could, you seal that?
You are not alone. That's Michael Jackson. Okay, I won't do that. Let's see here. So she's sitting by herself. She looks so creepy to me. To me. Is that it? Let me see. Oh, wait a minute. Yeah, she looks scary to me. I just don't know. Yeah, so what they did decide in the next hearing, and I don't know if you guys seen it, we did watch it earlier, where the homeowners was like, no, they don't want the jury coming out to their house, but the judge overruled it, and the jury will go out to their house.
All right, so what we're going to do is we'll move that final trial conference from 10 o'clock till 2 p.m. So it's going to be, next date will be June 18th at 2 p.m. And that'll be, the defendant will be here in person.
Yes.
That's the argued motions eliminate, jury issues, and check on the status of the examiner's reports.
Okay.
All right, anything else we need to address?
No, Your Honor.
Nope.
All right, well, thank you, counsel. Thank you, Ms. Clancy.
Thank you.
And we'll be in recess.
All right, so just for the record, the matter continues to June 18th, 2026 at 2 p.m. for the
No, I was just saying, she looks scary to me, but, that's just me, considering the situation. So that concludes everything that we have as far as our hearings and motions. It was good to hear, the different things that they disputed, that the jury is not going to be able to hear. I hope that most of this stuff they can streamline and we don't have those issues once we get in trial with all these sidebars and stuff, right? Let me get the Discord link in there for anybody that does not have it. If you want to go over to Crime Club, Crime Club will be happening soon. They'll be watching a movie over there from Netflix. We're gonna touch on that movie probably over the weekend, or we'll probably touch on that one. I don't know what day y'all talking about watching it, but I don't know, maybe Friday. We'll see. Let me get the link for Discord for anybody that does not have it before we check out of here tonight. Tomorrow we have our sentencing hearing. For my West Coast people, it is going to be at 6 o'clock a.m. We'll be getting started in regards to Coates' plea agreement sentencing. He did take a plea deal, but just please remember that the judge is going to be deciding Coates' fate. So, from a West Coast, Best Coast people. That is that for that portion. Yep, we are all caught up with all the hearings, unless there's something else that I'm missing out here that I didn't see. Y'all can let me know. So this case, opening statements will not be until Monday. The jury is seated. From my understanding, like, I don't know what they're really doing tomorrow, if they're doing anything tomorrow. It didn't sound like they were doing anything, but we'll kind of keep an eye on it. But from everything that I've seen, opening statements are Monday. Okay. Yeah, I don't know if y'all watching it tonight or tomorrow, but yeah, we'll touch base and try to get that together for toxic. Is it toxic love? Toxic love? Okay. And so yeah, make sure y'all go over there. You said it better be LWAP. I don't know. We'll see when we get in there tomorrow morning, Gabber. I don't know. I feel some different type of ways about it. And remember, Dad gets sentenced next week. So although we didn't get through all of the testimony, we'll still continue like Monday and Tuesday. We'll continue with Coates' Father Collins trial in the afternoons, because this trial will end pretty early in the day for West Coast people. It'll probably end about 2:30. So I don't want to give y'all too much time on y'all hands. Okay, so they said they're gonna watch it tomorrow. Okay, cool beans. So they're gonna watch that tomorrow, and then we will touch base in regards to, because I do got the transcript, so I want to kind of see what stuff they're not gonna cover in there that we can decipher from the transcripts and do some role play, some acting. All right, guys. Well, I'm gonna put our outro song on, and we will be back up in this joint tomorrow for our sentencing day. I'm so glad he took a plea deal and didn't take these families through additional stuff, additional trauma. And when I say additional stuff, I'm talking about Colt, because he could have had a trial and brought everybody that was accusing him of this stuff up and reopened all these wounds and stuff. I'm glad that he's taking the plea deal, so we don't have to go to trial in October, and the community in Michigan can start their healing. So I'm glad about that. So yeah, we'll see that tomorrow. All right, guys.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chatter showing out. This little YouTube corner's what community's about. Therapists you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, is always on display. Fair and sweet and cheering folks along the way. And Maria from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we'll forever take it to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Fowler brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. And Zach's trolling, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way to trial. Take it to trial. Shamrock keeps us trending, replay queen, holding down the algorithm like a machine. Estes razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white claws, way managing volunteers like she runs the whole land. Cynthia brings inside what takes sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard-lived, tries to support her with pride. Melly shows up her family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baca loves her gram, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind and vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shatters, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taking to trial. To Sweet Pea in the mouth and the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.